February 9th, it was a shocker. It really was. And actually, you know, the passing of Justice Scalia, people, I'm sure you all remember hearing about that. No one could believe it. It just seemed like, you know, the next thing would be the plague. But we really sort of saw a big change. And that is states that were opposed to this rule clearly said, we are not moving forward. Most of them were ready to say, we are not moving forward in those states that the Clean Power Plan would have had us move forward. And that's the key. So briefing is now ongoing. And what's very interesting about the briefing in the case is it's really forced all the parties to kind of put their issues on the table. And yes, there are purely legal issues about whether or not this is okay. But then there's so much policy that's coming out. The most amazing thing in some of the opening briefs are the companies who are saying, we can do this. This is not that bad. We can comply. We were already moving this direction anyway. Duke Energy filed a brief, or Dominion. The same just later in the week, Peabody Coal Company declares bankruptcy. So we've got all of these shifts happening while this kind of almost distracting litigation is going on about whether or not the Clean Power Plan is legal under the Clean Air Act. It's like a really narrow question when what we want to be talking about and what the companies are clearly saying and what 50-plus cities said in an amicus brief, a friend of the court brief, is, can we just get about doing this? This is what's happening in the energy market. Things are changing. Like, this argument over the Clean Air Act can keep us all very busy, but meanwhile, we're all just moving forward. So it's really, really interesting. Yes, there are states who have said we are not preparing anything that looks like a plan, but are they having conversations about an energy future in their state? Absolutely. So we'll talk a little bit about a few of those things, and then I'll kind of pause and let us have some discussion. So yes, there will be a lively litigation, but I think what's really important to think about is what EPA said to our members, my members, at our meeting a few weeks ago, which is what was stayed was the Clean Power Plan rulemaking under the Clean Air Act. What was not stayed was discussions about energy policy, discussions about electricity policy, discussions about innovation, discussions about technology. What also was not stayed was EPA's technical support to states. So they are willing to have conversations with any state that would like to come forward and talk with the agency about resources. The agency was not prohibited from having these conversations, from providing technical assistance, from helping states with analysis. And so the agency has made it pretty clear that they want to remain a resource. They also have been very careful to say that they are respectful of the stay, and that they will do nothing to implement the rule while it's being litigated. Meaning, in the response to a question from the state of California to EPA's general counsel at the ECOS meeting, would EPA, if California submitted a plan by September, would EPA review it? The agency said no. They would feel that they would not be able to review a plan because that would be essentially implementing the rule. So very, very interesting that there's a lot still open and a lot of opportunity. The other thing that is an open question is what will happen to the deadlines? So when will we have an answer on the litigation? The arguments before the D.C. Circuit are June 2nd and 3rd. Very unusual for the court to reserve an extra day for argument. Lawyers and legal geeks will be lining up seriously. It might be like a Springsteen concert. People may be outside on the steps of the D.C. Circuit to get a seat in that room. Any of you who are VIPs or have friends, you know, now is the time to cash in your front row favors. It's going to be a terrific argument and very, very lively. Then whoever wins, okay? So if the states win, if the D.C. Circuit says, EPA, you went too far in the Clean Power Plan, you don't have this authority under the Clean Air Act, perhaps the only authority you have is for building block 1, right, within the fence line type changes. Well, of course, who's going to appeal that? EPA, right? This is precedent setting for them. And if EPA wins and the court says, well, you know what, there's some ambiguity here, there's some conflicting legislative history, why not? This looks like a reasonable interpretation of the Clean Air Act by the agency, and we're going to defer to the agency, which the court sometimes does. Well, who's going to appeal that? all the states that are opposed and all the industry groups through their trade associations that are generally opposed. So the soonest we might see something before the U.S. Supreme Court is 2017. And so we've got a while here. Spring of 2017 is the earliest we might see a decision out of the U.S. Supreme Court, or we might even hear arguments, but we've got a while. So in the interim, keep an eye on the following things. What are companies doing during this day? As I said, a good example is we have changes in coal companies and their financial abilities. We see changes in the companies like Dominion's brief supporting and saying we're going this direction. We're going to see a continued push towards renewables, continued push towards natural gas. Keep an eye on your state legislatures. The state legislatures are very active in this arena. Good example, Oregon recently enacted legislation to go zero coal in Oregon. We've got Wisconsin with a brand new renewable portfolio standard. We have Maine with a new wind energy program, new energy efficiency programs. So all of that's happening, and all of that's going to affect where we're going. Also, you see legislative action around the Clean Power Plan. Good example, the Virginia General Assembly passed a requirement that the state would have to submit their implementation plan to the state legislature for approval. The governor vetoed it. So you still see, lots of skirmishes around the Clean Power Plan, but then you just see other things happening. You also saw in Colorado, a state that has been really divided on this matter, a zeroing out of the Air Division budget by the Republicans in the legislature because they didn't want anyone working on the Clean Power Plan. They just reached a compromise about 10 days ago where they cut the equivalent of 2 FTEs budget from the Air Division, which would have been the money that could have been spent working on the Clean Power Plan. So a symbolic adoption of a budget that would say, we don't want people working on this. The governor said, in reality, no one's losing their job, and they're just going to be shifting people to doing other clean air-related work. And that brings me to this really cool chart that I'm sharing from the Association of Air Pollution Control Agencies. Years ago, there was a graphic called the utility train wreck, and some of you may recall it. The utilities used it frequently to show how they were being, overly regulated, and all these deadlines were sort of crashing on them at one time. This is a little bit different presentation of maybe many of the same things that were in the utility train wreck diagram, because there are a lot of rules. This is a listing of all the different Clean Air Act deadlines affecting states before the initial compliance date of 2022 of the Clean Power Plan, assuming it's not delayed. And as you can see, there's a whole lot going on under a lot of different requirements. We've got SO2, fine particulate ozone, the old ones and the new ones. We've got lead, we've got haze, we've got changes in state implementation plans. And one argument that has been made is, might we see some reductions in greenhouse gases from these other rules along the way? Some of these rules control precursors to GHGs. So might we be in a different place by 2022? We don't know. But I think that states feel that with this kind of investment by the sector, not only the regulators, but the companies who are going to have to put in all these controls and all of the transportation changes that we're going to see in fuels, so much is going on that there is going to be an improvement in air quality overall. And then do we look at the Clean Power Plan maybe in a different way in the context of all of this? So I'm going to stop there and turn it to my fellow panelists, or back to Carrie, and look forward to the discussion.
Thanks, Alexandra. Now I'd like to introduce Chairman Kane from DC. She's also on the National Council Executive Committee. Uh-oh. We're good.
Here. Thank you very much. And thank you, Alex, for that terrific kind of roundup and perspective on this. When I was first asked to do this, I thought it was sort of odd because we're the District of Columbia is one of the 2 jurisdictions that, at least in the continental U.S., is not covered, that doesn't have to file a Clean Power Plan because we don't have any fossil fuel generation that's over the 25 megawatt threshold for being subject to it. We do have a couple of generating gas-fired generating systems that are in the 7.5 to 8 megawatt. They're all owned by the federal government. One buys the Capital Power Plant, which has a 7.5 megawatt gas-fired turbine, which is currently used for steam, but they're adding another one that will be used for produce electricity, go back to the original purpose of the power plant at the U.S. Capitol. That's under the control of the architect of the Capitol. And then the Federal General Services Administration, which buys the power and manages all the buildings for everything except the military in the district, and actually consumes about 25% of the electricity that is consumed in the district. They have a very large steam plant down in southwest D.C. that, again, is used for steam. It heats a lot of federal buildings. It heats a lot of, actually a lot of city-owned buildings also, including our public library, et cetera. But they also, the electricity that it generates as the byproduct of that, they sell into the PJM market. I have no idea how they would comply with the Clean Power Plan, and what the Congress seems to think they're a law unto themselves for that. But that's all we have. But nevertheless, while I thought about it, I thought that whether or not a state has to comply with the Clean Power Plan with the capital C's and the capital P, we're all affected by, first of all, what all of our fellow states do, and also by, and thank you, Alex, for this, we're affected by everything else that's going on. And so there were a couple of themes I wanted to kind of set up to talk about. And number one was the kind of theme of the overarching theme of today's and yesterday's and today's meetings, which is the blurred lines. Where do, Alex mentioned a whole lot of things that states themselves are doing through state law, through mandates at the commission, through renewable portfolio standards, et cetera. And then there's also what I call the kind of internal issues. That's my backyard, federal versus state, sometimes figured out legally and sometimes not. And then there's the within the state, or within, in our case, within the district. You've got your Clean Air Agency. You have your maybe a separate environmental agency. You have a state public utility commission. You have sometimes an energy office, which we have an energy advisor to the governor. And so you've got maybe 4 backyards, at least in most states. And then you have something like air, which doesn't stay in anybody's backyard. It just moves. And we've seen that way back with transportation, with the ozone transport and other things, and us states in the east saying that all the dirty air is because of what comes over from the Midwest. I'll give you an example. In the District of Columbia, we have our State Utility Commission that I chair. We have a department which now has been renamed as the Department of Energy and the Environment. It used to be just the Department of the Environment, but they did have an energy role, and they have to do the clean air and the clean water, as well as hazardous materials and other things, and fish and wildlife. We actually have fish in the Potomac River. We give out fishing licenses. But when the Clean Power Plan first came out, that first round of comments, excuse me, on the first one, our Department of Energy wrote a glowing comment, totally in support of it. This is wonderful. With clean air district, we are committed. We have very aggressive renewable portfolio standards. It's wonderful. Never said a word to us. I opened the Federal Register and read this, and call up the head of the department, who I know very well, and said, George, it was George at the time, I said, what about reliability? What about affordability? Both of which are things that they are also parties in our cases before the commission, and they're always in there, the Department of Energy, because they run the low-income assistance and LIHEAP and weatherization, always saying, we've got to keep prices low for low income. And they said, oh, yeah, all right. So, it was like, this is a little tiny, 10-mile square district, and we weren't talking to each other. So I can imagine in a state where you have all these other agencies. Well, we did file a second round of comments where there's a whole last 2 or 3 pages it said, but you also need to consider reliability. You need to consider very seriously the impact on affordability. You know, what is the purpose of all of this? And also we need to consider what is the impact of what other states are doing on a neighboring state. And then, and also I don't know if you have on this chart, Alex, the generator rules. The generator rules. The 15 hours versus the 100 hours exemption for generator rules. We're sitting here talking about demand response. We're talking about, you know, islanding and microgrids and all that new stuff with electricity policy, some of which depends on people having backup generators. And yet we get the exemption, the emergency exemption for generators to run up to 100 hours a year, which has just been shot down in the court just about a year ago. So there are all these other things that are going on. So it's not just the Clean Power Plan. All these other things which various state agencies are dealing with. Probably none of us who are commissioners are dealing directly with any of these air quality things, not to mention water and the interaction between water quality and operation of power plants, et cetera, et cetera. So the questions that we wanted to kind of throw out in looking at our think piece again is, you know, well, one was how does the state on the implementation affect the activities in your arena, and where are states taking coordinated action and where have states hit pause? And I know there have been various charts and things that have been put out showing what states are doing, but it's probably changing daily as state legislatures are in place and wrapping up things, as commissions are making decisions about new substations, about new power plants, about new power lines, et cetera, as well as renewable portfolio standards, and particularly what resulting information gaps that exist, and it would improve, could improve policy making. Certainly even just something like this chart I'll start with, that, you know, for people to be aware of that and how that impacts it. But I want to throw that out. Anyone ask for some, first of all, some reactions in terms of what's going on in your state, any updates. I saw, Joe, quotes from your governor about, so I'm not quite sure where New Jersey is. That's her governor, all right. All right. Quote unquote, your governor. You know, this was the New Jersey Department of Environmental Protection, and this is your Environmental Protection Commissioner, said that it's unprecedented regulatory overreach, and it punishes New Jersey, which is an important part, already achieved significant reductions in carbon emissions, setting even stricter goals for them, even though many states have made much less progress. And, you know, just compliance with this. Okay.
As far as New Jersey is concerned.
Okay. I don't know if either you or Mariana want to add on that. Go ahead.
Because many, or some of the things anyway, we have achieved over the years, and we feel in some cases we may be being penalized because we did achieve. Maybe we achieved them too soon. And in achieving them too soon, we're saying, or we're being told, that we're not in compliance, which is kind of unfair, I think. Do we have anything?
In addition, when 2019 rolls around and Oyster Creek goes offline, you know, obviously our greenhouse gas emissions are going to go up, because what's going to replace it if the NRC doesn't get off its ass and approve the small modular reactors that can be put in place, maybe some of these coal plant sites, you know, that's a tremendous amount that we're not going to make up with. You could cover the blanket the state in solar, and if there's any offshore wind, it's never going to make up that base load.
And I think we're being short-sighted as far as nuclear and things of that sort are concerned also. That's my personal opinion.
Which brings up, that's another backyard, the NRC backyard. Mm-hmm. And who's playing there, and what's the, what else? Yeah, I think. Oh, Kim, yes, North Carolina. North Carolina has been cited in here, as well as Duke, and Go ahead.
Thank you. Question for Alex. Yeah, Kim Jones on staff in North Carolina. I really appreciated kind of the update about what's going on because, frankly, given this day, I've been looking at other things.
That's what's going on.
But so when I sort of left the party, EPA, part of the package was they had some clarifications in process that they were going to publish this summer, like what does a model federal plan, if you don't submit a state plan, what gets foisted on your state? And I was just wondering, given the stay, do you know if they're going to go ahead and publish that this summer?
My understanding is that they're not. We asked them at our meeting if they would be publishing the model rules, and my understanding is that no, because it's sort of very related to implementation. One thing that they are talking about still exploring is the CEIP, the incentive program to sort of reward early action. I think that the commissioners from New Jersey make some really good points. One of the questions we asked is, every time there's a pause, people that get ahead, or states and groups that get ahead, or companies that get ahead, seem to sort of get penalized maybe on the back end for that. And would that trend or that pattern affect what happens in the interim? And EPA said that they would not change the baseline year. So continued reductions will still be counted, so going forward. I like the analogy of leaving the party because it's like there was this big clean power plan party, and then just all of a sudden, the smoke alarm went off or something, and everybody like cleared out. But there are people still hanging out, behind the bar and, talking, and it's a great analogy.
It's a great analogy. I used to be executive director of our retirement board, and every agency had to have a fire plan, and where you would, where everybody would gather, so the fire marshal could count who was there. And we picked the bar that was across the street from the office building, where everybody used to go after work anyway. So we, figured even if they hadn't been at work, we'd find them there. No, that's okay. I've got a couple down here, and I can't see your names, but let's start with the first one that I can see closest to me. There.
Hi, Al Freeman, Michigan staff, and I have a comment and a question. First off, in Michigan, we tried to be a little bit more proactive and engaged a private company to help us do some modeling, and that was over $200,000, and now we don't know if that information is still going to be relevant when the stay one way or the other is resolved, and that's very frustrating. And we also bump our heads against our state attorney general, who is against the Clean Power Plan, while the governor isn't quite as angry towards it as the AG is, which complicates things as well. And Marcus might have some comments on this as well. We've had a little bit of conflict with Wisconsin over some coal plants closing in the Upper Peninsula, and that's a tricky thing to handle when a coal plant in a remote area is going to be retired. Finding a way to put more resources there, or more transition to figure out how you're going to pay for it. It's really been a Gordian knot to try to figure out how to do it in an affordable and a reliable way. And then my question is and I don't know how many attorneys are in the room, but have any of the briefs started to come in for the DC Circuit case yet? And is there anything, if they have, is there anything surprising in the brief so far, or is it pretty much everything that's already been seen, but with some new paint on the walls?
Well, the briefing is in the initial briefs for all sides and the amicus briefs. There've been some really there's been no surprises. I think that this was one where everyone kind of knew that the argument was going to be over the ambiguous legislative history, whether the Clean Air Act was designed to actually go this far. There's actually legislative history that indicated that Congress was not trying to get into carbon, when they were working on the Clean Air Act in 1990. But again, the Massachusetts v. EPA case sort of put that issue to bed. I think whether EPA has authority to regulate carbon, whether carbon's a pollutant statute. There was an interesting amicus brief from former members of Congress who were around when the 90 Act was passed, so lots of people kind of revisiting their days of glory, so to speak, and what was going on. There's a brief from former EPA administrators, both Republicans and Democrats together, saying this is doable, this is inevitable, and this is, of course, all happening while on Friday, on Earth Day, you know, John Kerry and carrying his granddaughter signs the Paris Agreement. You know, it's this sense of how can you be against this because this is how the world is going.
Yeah, Bill Edge from Georgia. Georgia has stopped planning entirely because of the stay. All 5 commissioners on the day the rule came out spoke out against the plan, and I believe all of our state officials have filed against the plan. But one thing that they pointed out was the original rule did not give us credit, acted as though the new nuclear reactors under construction were already in operation. And the EPA did change that and give us credit in the rule that came out in August of 2015. So they were pleased with that, but they're still opposed to the rule.
Can I add something to that? Cherie Cunningham with the Georgia Public Service Commission. As Bill said, our EPD did issue a statement saying they're going to cease all work on it because we have been meeting, you know, just furiously every week almost, getting ready to do outreach for the CEIP and doing all that planning. But they said they're stopping, but under the course of our normal course of business, which is integrated resource planning, the company has proposed to add more renewables, which we are on track to. We are on track to have a lot of renewables in Georgia. You know, Georgia, as quiet as it has been kept, has a lot of solar at the military bases, large-scale solar, working on DG, all of that. So, and we were already on track under the proposed rules to kind of meet the goals anyway, you know, without doing anything. And this was prior to the 2016 IRP that was filed this year. So they're talking about adding more renewables, continuing the energy efficiency programs that have been in place. So, and we're still meeting with Nicholas Institute, which hosts our regional Southeastern Environmental Leadership Forum, to look at modeling and analysis and all that for the state. So we are being active, and CPP is being addressed in the IRP. So we're still busy.
Good morning. This is Darren Carney, South Dakota Commission staff. First, I want to say that, you know, the goals may be achievable, but the EPA still needs to act within the authority it's given by Congress, and hence that's what's going to be the ultimate issue before the court. Not an attorney, just my opinion. Also, in response to Alexandra's comments that utilities have filed in support of the rule, there are probably an equal number of utilities that filed to oppose the rule. And the reason is it's because of the resource mix they have in their backyard and the asset or the age of their plants. And so ultimately each utility's position is different. I know the Midwestern co-ops are going to struggle to meet the rule because they built a lot of coal in the 80s, and those plants are relatively new. It's kind of like driving a car, right? If you pay a car off in 5 years, you're going to drive it for another 5 years where you don't have a $300 payment until maintenance becomes too expensive, and then you go back and invest in a new car. Well, if you have a depreciated coal plant, and all of a sudden you're going to shut it down and add another facility, whether wind, solar, or gas, that just goes into the rate base again, and then ratepayers are going to end up bearing those costs. So ultimately, it depends on you know, the utility's specific position, whether or not this rule could hurt their customers or not. And finally, I would just note that, you know, if the EPA believes that this rule doesn't really mean anything because the market's already picking the resources that are reducing carbon, then why are we all here wasting our time and money talking about this stuff, and just let the markets pick and choose? Thanks.
We've got Wisconsin there, and you were called on, or you were called out, so let's go see.
That's right. I was addressed by my neighbor across the lake. Which I'll get to that. But first, I believe there was the Wisconsin RPS has not been updated. I sit by the RPS compliance guy, and I haven't heard anything on that. So I don't know where that's coming from. But anyhow, we did meet our 10% goal early. There's changes all over the place, yeah. But, so just wanted to clear that up. And then I thought the point that Al brought up about retiring a coal plant in a remote area, and that's a really illustrative example of the kind of timelines that are involved in planning for meeting any sort of change from the Clean Power Plan, because there are transmission solutions for reliability, there's generator solutions, you can change your fuel mix, and so that's a really good example for just how complex big scale changes within the ISO RTO world can be. And that's why Alex's point about the unknown timelines after a decision from the courts is really key, because then that directly flows into all the planning at the RTO level and at the state level. So I think that's a pretty key example. And then just getting more through Wisconsin, which is challenging the rule and has an executive order against planning for compliance. It was a pretty narrow executive order in that we can't be planning for compliance. So we still are monitoring what MISO is doing as far as their transmission planning and things like that. And we encouraged MISO in their transmission planning processes to look at a more generic carbon reduction future instead of a very detailed, CPP rule-like future where the rule and the makeup of the rule could change, let alone the timeline of the rule. So we were more interested in seeing, planning for a future where, as Dan mentioned, the changing is happening and there's carbon reductions occurring, and they can still be significant carbon reductions, but just not to some well-defined, prescribed rules, which lead to all sorts of interesting results based on the letter of the rule. So that's where Wisconsin is at.
Thank you. Kim, you could put it down. Okay. People have mentioned MISO and that kind of planning, et cetera, is going on. We know PJM has also been doing modeling and is probably spending a lot of time and a lot of resources. I don't know if there's anyone to talk to what's going on there. Who am I seeing down there?
This is Dan, South Dakota Commission staff. I can't speak to PJM, but as far as SPP is also planning for carbon-constrained futures. So the RTOs are definitely considering it, like what Marcus said. And, as a state, South Dakota has kind of stopped work on the Clean Power Plan, but we're still watching what the RTOs do. And, carbon's going to be constrained in the future. I think we all know that. It's just a question of how, and the RTOs are planning accordingly and making sensitivities to run on that.
Okay. I'm going to, Grace, from our staff, who's whatever I said, talk a little bit about what PJM is doing, because most of the states, or a good portion of the states in PJM, and certainly the Mid-Atlantic, are restructured. So when you talk about power plants, those are very often not even under the control of the Commission. But what's going on in PJM with Clean Power Plan?
Well, PJM is working with the states and the EISPC, Independent State Agencies Committee, to make sensitivity runs and to figure out exit entry policies, what kind of exit entry policies have on the future prices, capacity and energy prices. But at the same time, they are saying, these scenarios really didn't represent what will happen in the future. So if you want a crystal ball to see exactly what will happen for the prices or reliability, like Chairman Ken mentioned, those key objectives and states really concerned about, we don't have a crystal ball, for example. And I understand the states are working on, their own objectives, and it can be mass-based approach, it can be rate-based approach, it can be a mix of both. The difficulty is how to forecast the prices and reliability for the future, and when states are adopting different approaches. Some states already joined cap and trade. They probably don't need to do too much. And some states are figuring out, the detailed manual, energy efficiency, renewable energy, et cetera, and demand response, and how to achieve the final objective. And I mean, when you ask PG&E what kind of price impact you anticipate, at the beginning they told you maybe several bucks per megawatt hour, but then later on you ask them exactly how much. They said they are still doing the study. So suddenly, the picture is quite blurred, and I heard MISO has some issues on the reliability, and I don't know whether that has been resolved. And when you look at large-scale retirement, coal retirement, and natural gas combined cycle plants comes in, and suddenly it's very hard to model, but I think that's some information gap I really hope to see for the future. Thank you.
Dennis, what's going on in New England? Dennis? Okay.
That's one area that I really try to stay out of.
Well, maybe I'll just comment. The red states certainly are, continuing to move forward under their program. It reminds me of like back in high school when your teacher said you were going to have an exam and you were cramming, and then all of a sudden the exam was canceled, right? That's sort of what the CPP dialogue has been about. There were all these really hard questions that were being asked, like could MASH trade with MASS, or what if neighboring states, as you mentioned, adopted a rate and MASS? What if Florida wanted to trade with Wyoming? Or all these questions were being asked, and they were really hard, and there really were no easy answers. And now that the court has pressed pause, it's like everyone's like, oh, good, we don't have to do that. And so what I've been looking at is from a policy standpoint, and I think the reference to the Nicholas Institute and some of the other think tanks are still filling that intellectual policy area where they are trying to answer some of these hard questions, because the reality is, in about a year from now, the teacher may reschedule the exam. It may look different. It may, but I think the comment about the carbon-constrained future being a certainty means that trying to answer some of these hard questions now isn't a bad thing for states. The other thing that I've thought about is the arguments against the rule, and I think South Dakota's staff member made some really good points, are legitimate. But one of the big arguments from many of the states was, we don't have to be told to do this under the Clean Air Act. We're already doing amazing things in Texas, in other places. And it was sort of a states' rights argument. And so this, to me, is a time when states can sort of shine, if you want to say, that if there were interesting, dynamic things happening in the states, there's a window in which the states can kind of demonstrate that they didn't need to be told. Now, to the point that, so why shouldn't the rule just go away? Well, remember, it was a political rule all along, right? I mean, this is part of a political agenda. We have an election ahead. If we have a continued Democratic administration, this rule is going to be around in some way, shape, or form. If we have a Republican administration, I can predict that it probably will not be around in some way, shape, or form. But will the carbon-constrained future still be around? Maybe. And so answering some of the questions now isn't detrimental, I think.
Alex, well, these all things will still be around.
That's right.
And what, briefly, two questions I have that could fill in, because we're talking about what information gaps. First of all, on the 100-hour rule, which on the generators and whether they could run even if they didn't meet the air quality in quote-unquote emergency situations and backups and things, which was remanded to EPA to do revised rules. Is there any information you have about status of that revised rule?
I don't have that with me. This is what they teach you in law school, right, to say, thank you, Your Honor, I don't have that answer at this moment, but may I get back to you with a supplemental filing? So why don't I follow up with Miles and Carrie and see if we can get some little blurb about that.
Okay. And then on these state Clean Air Act deadlines, which many of us, I mean, some of them go back to 2008 on the ozone, which we've always sort of more as affecting transportation and automobiles, et cetera. Here's a quick run through on any of these that might have some particular direct implications for electricity policy.
That's a great question. So the ozone battle is another battle royale that is going on. I mean, it's already in litigation. Fewer states, but this is where the western states are. The ozone proposal is now basically at background levels for most of the West. And this is where, again, I think the Clean Air Act is proving to be a bit of an awkward tool to deal with the issues. What states are saying, as you've mentioned, is they don't have the ability to directly control a lot of the sources. It is transportation related. What they could control, they've pretty much gone after. And so we're starting to see a lot of creative partnerships to try and achieve these ozone requirements. The other issue is that there are 3 sort of exemptions within the Clean Air Act for ozone exceedances, and they are all really awkward. One of them has to do with international border issues, which can be of some help to some states, but very few. There's another exemption for rural areas, which is not helpful in the West because of the wide landscapes. And then there's another exemption for natural sort of issues, weather. And the documentation that states have to put together to qualify for any exemptions is really burdensome. So I don't know if the ozone will directly impact electricity, to answer your question, but I do think that it's proving that the Clean Air Act could probably use some modernization, but there's no hope of that anytime soon.
Jeff, Richard.
Thank you. Just as your discussion was going along there, doesn't that really take the wind out of the sails of it being a state rights issue? Because, as you say, or said, Betty Ann, the air doesn't stay in your own backyard. So there has to be more, in my opinion, more of a national approach in order to help to reduce what we all want to reduce ultimately. So as far as the state's rights, I mean, I'll just say, New Jersey can do everything right. Rarely do we, but we can do everything right. But if Pennsylvania doesn't do everything right, or New York State doesn't do everything right, or whatever, it kind of nullifies what we're doing, or certainly reduces the impact of what we're doing. So I find the state rights argument weak in this particular case.
I think that's a good point. I think that the argument is more persuasive in the bigger states, the larger square footage states, square mile states. The Northeast, I think, is unique. Literally the days before the ECOS meeting, there's now a request from the northeastern states to have EPA step in and declare, a bunch of other states as contributing to the air quality problems in the Northeast. They want to bring in states towards the south and states in the Midwest. And so there's a lot of finger pointing in the congested eastern part of the country. When you go west, I think the states have arguments that perhaps they're not quite as proximate, and so they have slightly less impact on one another. But I think you make a good point. It's like we want the cake and eat it too, right? We want to do everything right, except when we need the federal government to make somebody else do something, in which case we would like to make other people do things.
So I know the ozone annex has been around since 2008, and there's some July 6th this summer and July 18. Any of these others that have a more specific, proximate impact on electricity? Yeah. Sulfur dioxide, obviously.
Well, I mean,
regional haze.
To the extent that they affect stationary sources, and a lot of them are generators, and a lot of them are electric users, okay? So they're consumers, they're purchasers of energy too. So, you know, all of this means that entities are going to have to be looking at how much, you know, combustion is occurring, how much they're emitting, so that they can meet these requirements. So you could see changes in demand.
Speaking of demand, the last one I'll throw out, when we think about clean air, we think about transportation, we think, oh, electric vehicles, that's going to solve it. You know, I talk about, will electric vehicles actually contribute to higher carbon emissions or lower, and particularly in charging and off-peak hours and on-peak hours, and like in D.C., everybody's going to charge there at work during the day. Any thoughts about that, where something you think is going to solve the problem, and when you look at the larger picture, it may be a lot more nuanced? But maybe we've just identified an information gap that we need, which is one of the things we want to do. Go ahead. Being the densest, I'm calling on Joe a lot because I'm a Jersey girl.
That's right. That's right. And we know that, and that's why we always...
And your chairman and I were born in the same hospital.
Is that right?
But like 20 years apart.
Oh. Is that like going to the same high school at different times, or graduating from the summer?
Like that.
I forgot now what I was going to say.
You were talking about electric vehicles.
Yeah, oh yes. Which is a great idea, but David, you mentioned yesterday you pull one string and you don't know what the ramifications are going to be with all the other strings that you haven't even thought about, probably. And I guess a lot depends on how are those electric vehicles powered? What is the power source? You know, is it a coal-burning plant down the street that's powering those, or whatever? I think these things all sound great, and it gets back to some of our discussion yesterday, I think, in trying to evaluate what, I guess really the bottom line, where do you get the most bang for your buck is really the bottom line, and so on. And is that the direction, and is that going? Not one thing is going to solve the problem, in my estimation. It's going to take a lot of things to solve the problem. It's going to take a lot of solar panels, wind turbines, storage. You keep naming it. It's going to take a lot of stuff to solve the problem. It's like a jigsaw puzzle, and our challenge, I believe, is trying to fit all those pieces of that jigsaw puzzle together. And that's really what the challenge is, and we do a lot of talking about that, as we said yesterday, right? But that's the difficult part. I mean, it could be a 2,000-piece jigsaw puzzle, and we got to fit all those little pieces together, making sure that we're not pulling the wrong string. You know, so that's really a difficult thing. But maybe if we do keep talking, and maybe if we do keep exploring, we may find answers as we continue down the road. The important thing is that we're trying to find those answers.
Kim, you can get Wynn, and then one more down there. Oh,
I'm actually gonna. I'm not the artist known as Kim Jones. I want to steer us, because we have used most of the time allotted towards some of the information.
And we've got one more down there too. One more question, Miles. Are you finished?
I have like maybe 5 things, and yours is one of them, as sort of initial points of information gaps, and then I think, Darren, your idea will, I'm sure, segue smoothly into it. A few things. One is that the APCA thing that is so elegantly displayed up on the screen makes me wonder if there is maybe a broader calendaring, road mapping, future identification exercise where we just plot some of this stuff out, not just within the air regulator stovepipe, but across a number of other kinds of issues. That could be an information gap that, instead of just one map, would it be useful to have a map that's multidisciplinary? A second is Michigan raised the idea, Al mentioned that y'all had dropped a decent amount of blood and treasure onto modeling, and you're not sure if it is now extended past its sell-by date, which makes me want to raise the question. We're often offered the panacea of modeling, and I just want to raise the question of, is modeling really something that at this point we know enough to ask for modeling? Is that something that's actually useful? The third thing that I heard was DC talking about how difficult interagency communication barriers, inertia was, even within DC. And so I think an area that we may want to start making a list of when we leave here are what are the collaborative tools that help us overcome those pieces of inertia. I think us sitting in the room together is an example of a starting point, but being more specific may be helpful. We had originally planned, NARUC had originally planned to do a meeting on trading scenarios where we just kicked around how does trading work under different scenarios, and what at a broad brush level are the market and technology interactions that you get when a state like New Jersey trades CO2 with a state like Florida. What happens to the energy markets? What happens to RTO markets? What happens to RPS compliance? Just at a broad brush level, so you can see if there's big unintended compromises. Darren raised very effectively this question about the relationship between plant depreciation and unexpected new mortgage features on those depreciated plants. Is there a relationship between how we depreciate plants and how we plan plant depreciation and the introduction of carbon pricing? And can we ask for and draw broad links between the effect on depreciation that the insertion of carbon pricing might raise? And then lastly, the question of EVs that was raised by DC and Jersey. I wonder if those emissions leakage questions have analogs out to other things that are not EVs. The backup generator rule is an example of demand response being introduced as a carbon compliance mechanism, and then you fire up your diesels and all of a sudden you've undone what you were trying to do. And I wonder if at a high level, more information about those unintended consequences when you get into leakage as you move out of the bulk system and down into the distribution system with things like EVs, backup generators as a component of demand response, how you're charging your Elon Musk, what are those things? Power walls, those kinds of questions. Those are some high-level things that I thought might be thrown out as I'm interested in what other things are like that y'all have heard today or that y'all want to raise today. Maybe let me let Darren make his point first. And
thanks, Darren Carney, South Coast staff. I just kind of want to make one observation from yesterday and today, and what it's going to come down to is at what cost and who pays, right? So for demand response, if they're bidding in the capacity market and PJM, at what cost and who pays for that capacity, right? And when you're talking environmental controls, environmental regulation, building new assets, it's going to come down to at what cost and who pays. And perhaps this is going to be linked nicely with the grid modernization project that's going to start trying to look at the value of all these various resources, and that will help us provide insight to us, you know, what the cost is, and then the regulator, whether it's state or federal, is going to have to figure out, well, who pays then, right? Once you get an understanding of the total cost that's going to impact the consumers of electricity, then it's going to come up to the cost allocation question. And those are tough discussions to have, but just kind of my little point of observation.
Kim, Kim, last word.
Sure, a quick one. So in the conversations about conservation's possibility of helping utilities with the Clean Power Plan, one of the little nuggets of wisdom I picked up was that the manufacturing sector is very concerned that they are the next target for something like the Clean Power Plan, and no, they really don't want anything they achieve in the conservation sandbox to count toward their utilities compliance, because they might need it for their own. So, and there's a question for you, Alex, which is, have you heard anything from EPA in terms of their plans to move on to other sectors?
Yeah, I wouldn't be surprised if they had announced a big effort to move on to other sectors. What they have done is they've moved on in methane, right? So they've got a big program on oil and gas now that the president announced a couple weeks ago with Canada's prime minister. So I've not heard them going after manufacturing yet. And they did drop that building block, you know, that fourth block. So what I think is interesting is we continue to see the manufacturing sector very interested in this conversation. Again, you know, they're out in the alley too after the smoke alarm, and they're watching their back a little bit. I think you're absolutely right. They're looking for opportunities. For example, we hear from forest and paper companies that they're looking for biomass opportunities. You know, so they've got all their cards out right now, I think, you know, trying to see what's the best strategy. But I have not heard a big initiative yet.
Turn it back to you.
All right. Thank you very much, Chairman Kane and Alex. Great job. And thanks to everyone for the good discussion and some of the, as we move into or morph into, you know, what are the information gaps and what needs to be done to fill those gaps. I think we came up with some really interesting thoughts, and we encourage you to keep thinking along those lines. What are the gaps? How can we clarify those blurred lines? And what can we as an organization and as a group of professionals in this field do to fill those gaps and move along on the track? We're now going to move into an area that, as we all know, coal has a big bullseye on its back, and we're going to be talking about the pause as well in federal coal leasing. And Miles is going to introduce the, no, you're not?
I am.
Yes, Miles is going, he forgot that he's, yeah. He's going to, but no problem there. He's going to introduce the issue, and Al Elzer, we're really pleased that Al is here from the Bureau of Land Management in the Department of the Interior, and we have, I believe, Ed McNamara from the state of Vermont, who is sitting in for Commissioner Hoffman, who was not able to be here from the Vermont Public Service Board. So let's have Miles, why don't you tee up the topic, and then we'll turn it over to Al.
Thanks, Jen. So we had a long list of potential topics where there are emerging question marks about jurisdiction, and I hate to admit that that list, if you looked at it without any kind of understanding of who was making the list, you would probably correctly guess that I'm an Eastern guy and that most of us are Eastern people. And this topic, we made sure to throw it on there because it's really a topic that affects the West probably more immediately than it affects the East. Because we're making this move from just being exclusively Eastern focused, I thought that made it especially valuable to include something where those of us in the East kind of start thinking a little bit about what's happening nationally. And the things that happen in the West are profoundly important to what happens in the East in this one domain, which I think in many domains, but this particular domain. It is extraordinary how much coal in particular comes from land that is leased by the federal government. A lot. We can get into the details there. But when you put pressure on one resource in one part of the country, it doesn't remain, it's squeezing a balloon. The effects are felt in other resources, in other markets, and in other parts of the country. And so what we're going to do today is we're going to kick around a little bit. What does it mean that the source of a lot of Western coal is going to be subjected to a non-air regulatory constraint? Is what we're reading in the papers about Western leases effects on resource extraction on federal lands, is that backed up? Like, what's the truth and what's the horse's mouth piece on this? We're going to have Al Elzer from BLM talk to us about what's actually the plan, what's actually happening there, so that we can get past sort of assumption and conjecture. And we're going to have Ed McNamara from Vermont, which, as you know, is a Western coal-producing state, which, as you know, is an Eastern ice cream-producing state. Talk a little bit about what happens, what do we need to think about if we're not a coal-producing state and we're not in the West? Does that still have an impact on us? And what are some of the questions that we need to understand better? And then we'll have a little conversation about it. It should be fun. So with that, Alfred, thank you for joining us today.
Thank you. Appreciate it. And thank you all for having me. I have to admit, when I was contacted to present here today, I scratched my head a little bit at the audience. And so I put together a presentation for all of you, hoping that I can unblur some of these lines, not just in what it is that the BLM does with respect to federal coal leasing, but also what our authority is, where we're involved in federal coal, which is really entirely upstream, but of course that affects everything, and kind of give you an indication of where we're moving over the next few years based on, in part, the Department of Interior's Secretarial Order 3338, which came out on January 15th, which had really two main components. One was ordering the Bureau to conduct a programmatic environmental impact statement or programmatic review of our federal coal leasing program, and two is this pause that has made some significant headlines recently in coal leasing. And I'll get into that a little bit closer to the end of the presentation and hopefully enlighten some folks as to what that means and what it doesn't mean, because as I think we all know here, you can't believe everything that you read in the papers, but you can certainly believe some of it. So just some quick statistics. This is probably stuff that everybody here for the most part knows. Probably the most important one for this audience, approximately 14% of our coal or of our electricity produced here in the United States comes from federal coal production. Most of that is mined out west, as has been noted, though we do have a few leases out here in the east, Alabama, Kentucky. But if you look at the federal government mineral holdings, most of the public mineral estate is out here in the west. We have very little mineral estate that we administer in the eastern states. And for the most part, that's not on BLM surface. That would be underlying private surface, so it's split estate situation. We have a lot of split estate, of course, out west, especially where you have the checkerboard pattern of land ownership around the railroads. But for the most part, most of the federal coal that is produced is coming from these western states. And in particular, the Powder River Basin of Wyoming and Montana and the Uintah-Piceance basins in Utah and Colorado, the Green River Basin in southern Wyoming, and a few other basins scattered throughout the west and the Rocky Mountain states. But again, there's a lot of coal that is mined elsewhere in the United States. It's just not under the federal mineral estate, so we don't have a lot of regulatory or really any regulatory authority over it unless it happens to be on federal surface, and then that's just a surface disturbance regulatory issue. So just to kind of clarify, talking about blurred lines with some of the agencies, in particular, these are, again, the upstream federal agencies that deal with coal mining. The BLM, of course, we are the ones that authorize mineral entry, so we issue the lease that allows operators to go in and recover that coal and sell it to market. And then we, of course, have inspectors on the ground, boots on the ground, that are out there verifying that production, making sure that the public is having that coal that is now being lease mined, that you're not seeing high grading going on, that everything that we expect to be produced and is producible gets produced. The Office of Surface Mining Regulation and Enforcement, OSM or OSMRE, this is another kind of our sister agency that has a significant role in the federal coal estate. In particular, they're the ones that regulate the mine permitting and the actual hole in the ground that's dug, or the hole underground, depending on where it is. So we authorize the mining. We, at the BLM, verify the production. OSM is the one that says your mine plan looks good, you can open this mine, you can have this disturbance, and just as importantly, they're the ones that hold the reclamation bonds. So when it comes to the final reclamation of those sites, OSM is the one that is with the states working to make sure that that is reclaimed back to as good as or better than the original state. ONRR, the Office of Natural Resources Revenue, they're the collection arm. They're the ones that collect the royalties and any of the funds that come in. And then, of course, MSHA is the safety arm of the federal government when it comes to coal. And again, this is all just prior to severance. There's a lot more federal regulation that comes in downstream, of course. We've got EPA that we've all talked about here at length, and FERC, a number of other agencies. I'm just going to skip over this slide. This just goes into the leasing authorities that we work under. If you're interested, they're there, and I know this PowerPoint will be posted later on to the website. This gives a little bit of context to the size of the federal coal program. It's hard to think in tons sometimes, although I think this group is better than most at wrapping their head around the number of tons that are mined or leased in any given year, or that are sold in any given federal coal lease. But you can see since 2005, and this doesn't include 2015 or so far the fiscal year 2016 totals, but in total, we've leased over 4 billion tons of federal public coal and collected, just in bonuses, $3.6 billion in revenue. And of course, the bonus is what the operator pays for the right to mine that federal coal. Once that lease is issued and they start mining, they still have to pay royalties on it, typically 12.5% for surface mining and 8% for underground mining, that sales price. So there's really two significant sources of revenue for the federal and the state governments, because it's very important to note that this is split 50-50, or actually 51% to the federal government, 49% to the states.
So before you go on, could you just go back a second? I think we're all wondering, what the hell happened in 2012?
2012, and actually that brings up, that's a good segue actually into hopefully the next slide. We've got this lighter color bar are the lease sales that we've held, the number of tons that were sold in each year, and then the darker colored bar is the actual production. So what happened in 2012? We didn't have a lot of sales. Sales in, the way it's set up now with the BLM leasing program is, for the most part, sales are in response to industry demand. Industry comes to us typically about 10 years before they know that they're going to need a significant amount of federal coal in a lease, and they apply for it. And then we move through the process. So there's a lengthy time of National Environmental Policy Act, typically a environmental impact statement associated with that, or an environmental assessment if it's a smaller project that can be tiered to a larger NEPA document. But the point is that all of these highs and lows are really just in response to industry's needs. So in 2012, where we had a significant amount of sales. I was thinking 2013 and 14 where we started to drop off. This was because we had, I think, 4 coal lease sales in the Powder River Basin. Powder River Basin is where the vast majority of all federal coal is mined. And it's also where we've got the 2 largest coal mines in the United States, some would say in the world, Peabody's North Antelope Rochelle mine and the Black Thunder mine that's owned and operated by Arch. Those 2 mines had, I think, 2 sales each that year, or there might have been 1 for Black Thunder and 2 for Peabody. Long story short is that the larger the mine, the more they're going to apply for in their leases. When those come to sale, you're going to see a significant spike in the amount of coal that's been leased on a year-by-year basis. But more importantly, I think when you look at the production totals, you see that production has remained relatively flat for the first part of the first decade of this century, but then in 13 and 14 started to drop off. I don't have 15 up here, but we do have 15 numbers, an even more significant drop-off. That comes as no shock to anybody in this room. We're seeing a decline in coal production, mostly in response, I think, to the glut in natural gas and natural gas prices. And this is just a slide kind of showing the revenue side of what I just talked about. The darker green are the royalties collected. The lighter green are the bonus bids collected. And you can see the light green is follows the leases to a T because that's where we're collecting bonuses from, or from those lease sales. And the royalties, you can see they're generally trending upward for the most part, the early part of this century, and then along with production have started to drop off. So what this really is kind of leading up to, all this background, is to give you an idea of what goes into the federal coal leasing process and how that affects everything moving out past the severance of that mineral. There's a number of steps that we have to take at the BLM or any surface management agency, though the BLM does the leasing for all of the federal entities except BIA. It starts with land use planning, resource management plans, land use plans. This is where lands are identified that are open to leasing, and this is typically before an applicant will come to the BLM and say, we want to lease this area. So lands have already been identified that are open to federal coal leasing, and that's based on a number of factors following our multiple use mandate and our Organic Act, FLPMA of 1976. The next part in the process, the applicant would submit their request to lease a tract of federal coal. We would go through the environmental analysis, eventually authorize entry by holding a lease sale, and whoever's the high bidder that meets or exceeds the fair market value would be granted that lease. Unless it's a non-competitive lease modification, which is another aspect of this. If it's an area that wouldn't see any competition and meets some other criteria, we can add lands by modifying a lease as opposed to holding a lease sale. But you still have to go through all of the environmental analyses. And then once that lease is issued, then OSM and the state can issue their SMACRA permit, which is their right to mine, and ultimately, once everything is mined, reclamation can occur. This is a very, very rough schematic of what it takes for the BLM to go from application to lease issuance. Most important here is, as far as timing goes, is this process, the NEPA process. Typically, that can take, if it's a large environmental impact statement that has to be developed, that can take anywhere from 5 to 7 years. So you can see that in and of itself is going to be a significant hurdle that the applicants are going to have to keep in mind when they're doing their planning for when they're going to need this federal coal. If they need the federal coal more quickly than that, we do have provisions for emergency leasing, which I'll get into here in a little bit, but it still requires a robust NEPA analysis regardless. So this is what is really kind of driving this whole process of application to lease issuance. So back in, I believe it was February or March of 2015, the Secretary noted that it was time to have a conversation on modernizing the federal coal program. And as a result of that, we weren't quite sure what needed modernization because we haven't really looked at the federal coal program programmatically in about 20 years. So in the summer of 2015, we went out and had 5 listening sessions across the nation, starting here in Washington, Billings, Montana, Gillette, Wyoming, not Salt Lake City, Denver, Colorado, and Farmington, New Mexico. And it was similar to, if you've been involved in scoping meetings, it was very similar to that, where we had a number of broad questions that were presented to the audience and asked for input, looking for ideas on what we could do to narrow down what we need to do to modernize the federal coal program. So some of those broad topics were royalty rates, exports, what can we do to promote greater competition, other questions, appraising, leasing procedures, lease terms, bonding. Again, I mentioned earlier on that OSM holds the reclamation bond. BLM does hold a bond for the lease to make sure that the terms of the lease are followed, but it's a much smaller bond than the reclamation bond, as you can surely imagine. And a number of things excuse me, came out of that, not the least of which was over 94,000 comments. Fortunately, once you drill down through that, over almost 93,000 of those were form letters from 12 groups. So in general, that would count as one comment with a lot of backing. So the written comments submitted in writing at those sessions, we had about 1,000 of those. Other comments, 198, bringing that total up to 94,000. We provided some synopsis of that to the Secretary, the Bureau of Land Management did, and as a result of that and certainly other factors that have influenced the Secretary, she issued on January 15th, 2016, Secretarial Order 3338. And as I mentioned, that really had 2 main components to it. One is this programmatic review of the BLM's coal program, and the second one is a pause on coal leasing during that review. Now, that's where I think the tie-in with this group comes all together. And the fortunate thing is that the Secretary recognizes that coal is an important part of the nation's energy portfolio. And so in keeping with previous pauses or moratoriums, as they were called in the past, on coal leasing when we had similar reviews, she had some limited exceptions to this pause. And we'll get into those in a bit. The programmatic environmental impact statements, there were 6 areas identified in the Secretarial Order that we were to focus on. And in the notice of intent to prepare that, there were some more, and this is in the Federal Register notice, there was some more expanding on that. You can certainly find that in the Federal Register, and I can provide a link to anybody that's interested later on. But more importantly, what were those exceptions and exclusions? The first thing was this exception for metallurgical coal. Metallurgical coal is much rarer than thermal coal used for steam, for electrical generation. And so it's been recognized in previous pauses and in this one that due to the unique nature of metallurgical coal and the smaller resource base of that, it wouldn't make a lot of sense to have a pause on that particular resource. Generally speaking, though, the Bureau of Land Management does not manage a lot of metallurgical coal leases. We have very few. Most metallurgical coal is out here in the east, and it's mined off of private mineral estate. So then the other exclusions to this would be emergency leasing lease modifications of 160 acres or less. Those are the two that would probably affect most the thermal coal leases, but then also lease exchanges, preference right lease applications. These are PRLAs that have been on the books since before 1976. And then pending applications that have records of decision or decision records. This is the other one in addition to these two that would have a significant effect on the pause. So this is a list, and this is on our website. If you go to BLM's website and drill down from what we do to energy to coal, you can find a list of the leases that are potentially excluded from and potentially affected by the pause. And this is a list of those that are potentially excluded or exempted from the pause. And you can see the tonnages here on the right-hand column. Most importantly, though, I think when the Secretary was developing her order, she noted that currently under federal lease, there's over 20 years on average nationwide of federal coal production that's been leased and is available. So these are the projects that are already either in the hopper and have a signed decision record or record of decision by the BLM or by the Surface Management Agency, usually the Forest Service, or fall under the 160-acre threshold for a lease modification. And that's what these are, the LBAs and LMAs, LBAs and LMAs. An LBA is a lease by application, and an LMA is a lease modification application. So where you see an LMA with a small acreage, that's most likely why it's been exempted. If it's an LMA with a larger acreage, in all likelihood it already has a signed record of decision, or it meets or was applied for under the emergency leasing criteria. Now this is a fairly short list. We've got, a dozen or so, maybe 14 leases. Those that are subject or potentially subject to the pause, in other words, those that can continue to be processed up until signing a record of decision that would either order a lease sale or order that the application be rejected. There's a list of about 26 or 28. These are also on the website. And the important thing to note here is that, actually a couple important things to note here. One is that the processing of these leases can continue. In other words, the NEPA work that takes so long can continue to move forward during this programmatic review, which is expected to take about 3 years. So some of these had recently come in. Some of them, a number of them don't even have the NEPA started yet, or if it's very early on in the NEPA work. So theoretically, many of these projects wouldn't really be affected by the pause, even though they're even though we are prevented from signing a decision record on those until the programmatic review is complete. In other words, more likely than not, that time to sign the decision record wouldn't even come until after the programmatic review is complete anyway. So it kind of brings us to where are we now with all of this. BLM is contacting, actually has contacted all of those that were on the previous 2 pages whose projects may be affected by this pause. And what we have asked is, first of all, we've identified your project as potentially subject to the pause. Is there information that you have that would suggest that it shouldn't be? In particular, would it meet the emergency leasing criteria? If it meets the emergency leasing criteria and we concur with that, then it's a project that could move forward under the secretarial order. The other important thing about that is that many of those projects that would be affected by the pause were already, at the applicant's request, on hold. The downturn in the coal markets over the last few years, we've seen it with Peabody, we've seen it with Alpha. A number of these applicants have come to the BLM and said, we really need to hold off on processing this right now. Will you please essentially posits at our request. And so those have been, many of them have been, for lack of a better term, shelved until the applicant comes back to us and says, yes, we would now like to continue with processing this. So we've contacted those applicants. We've gotten a couple responses back. We are looking at a couple of leases that may meet the emergency leasing criteria. There were a couple in North Dakota that were actually applied for as emergency leases that we're reviewing right now. And I expect over the next few months that we'll see several more of those trickle in that we'll have to review. And then, of course, the second part of the secretarial order, we're working on the programmatic impact statement. Today, I believe, the press release will go out announcing the date and locations for the scoping meetings for that review. There will be 6 of them across the country, starting in Casper, Wyoming, City, let's see, Pittsburgh, Knoxville, Grand Junction, and I'm drawing a blank on the 6th one right now. I knew this would happen. Excuse me, I have a cold. That's my excuse. But that will be announced hopefully this afternoon. And that is really the opportunity for the public, for the states, for the cooperators, for everybody that has an interest in this, in the federal coal program, in particular the BLM's leasing program, and coming to the table and giving us ideas on what we need to do to make things work better. This entire programmatic review is about modernizing the federal coal program, so we expect to hear a lot from environmental groups on one hand. We expect to hear a lot from industry on another. There are things that we can do, hopefully, to speed up the process, industry would say. There are things that we could do to incorporate social cost of carbon and more climate change analysis, the environmental groups may say. So there's a lot of things that we expect to be looking at as far as those scoping comments go. And this is where I'm going to get on my BLM soapbox a little bit here and encourage everybody in this room to reach out to everybody you can if you feel like this is something that will affect your constituents, your states, and come up with either a request to be a cooperator for the programmatic impact statement or substantive comments that will help us drive that programmatic impact statement and the things that we're going to be looking at over the next 3 years while we develop this document. And then the comments, of course, and this will be up on the website as well, can be submitted to this email address. And I mentioned that we received 94,000 comments just on the scoping meetings, the listening sessions from last summer. The press release is going out today for the scoping meetings, and we've already received about 10,000 comments just since we announced that we were going to have this programmatic impact statement. So we're getting a lot of comments. There's a lot of interest in this. As you can imagine, most of those are probably form letters, but there is a vested interest by a number of parties in making sure that this modernization is taking into account everything that we really should be looking at. So on that, I'm going to turn it back over to our moderator for today, or
yeah, thanks, Alfred. So I have one question that you triggered in my brain about the causality between, so it's not a big secret, Arch and Peabody, the coal companies, or some of the coal companies, some of the big ones are on the ropes. Are the economic hardships that they're going through driving their interest? I'm trying to figure out causation here. Is the pause in leasing because the companies are in trouble, or are the companies in trouble because there's a pause in leasing, or are there two directional flows there?
I think it's two directional and two different pauses. Prior to the secretarial order coming out, I mean, I was working in, before I came back to Washington, I was actually in the Powder River Basin with the Bureau of Land Management, kind of boots on the ground with my staff out there, working hand in hand with Peabody, with Arch, with Alpha. And it was very clear over the last few years that some of these companies' priorities were shifting. And so it's been really over the last 3 or 4 years that we've been receiving those requests for delaying, that's what we would call it in the past, now we're calling it a pause, of processing those applications. So that was one kind of self-imposed pause that industry had brought on itself, or it at least had approached us itself with their request. And that was, you know, again, market-driven for the most part. The secretarial orders pause is really, the idea behind that is if we're going to have a programmatic review of what we're doing, it doesn't make a lot of sense to continue with the status quo during that review. So the pause is really to prevent any new lease applications coming in that we're going to start working on, because we want to make sure that if we make changes to the program, we're making those changes and applying it to those projects that are coming in, rather than expecting to see a rush of projects while we do this programmatic environmental impact statement, so that perhaps they wouldn't have to be included in whatever findings there were and whatever changes we made to the program. So that's, I think, one aspect of the pause. And then the other aspect is what's not affected by the pause. And that's where I go back to the Secretary recognizes that, you know, coal is still an important part of our energy portfolio. There's a number of projects out there that need to move forward, already have an assigned decision, may meet the emergency leasing criteria. And then really that, the other one, the 160 acres or less lease modification, that was in keeping with the previous moratoriums that we saw back in the 70s and 80s. That was also an exception that was allowed during those pauses. So she continued with that theme.
All right, good. So I want to turn things over to Ed McNamara from Vermont. Ed's going to give us a little bit of like a, what is this, you know, what's your reaction from out in the States, and we'll try and steer that towards understanding, does this matter to the states who are convened here, and if it does, what are some of the contexts?
Great, thanks, Miles. So as Miles mentioned earlier, Vermont's not exactly known as a coal state. Our last coal plant closed 35 years ago, and I think that was only a 40 megawatt plant. So I'm going to instead focus more on the analogy that Miles used at the very beginning of squeezing the balloon. What happens out west, and how is it actually going to impact all the way into New England? So the Northeast generally, and New England in particular, there's a lot of concerns about gas constraints. Right now, New England is over 50% reliant on natural gas for energy. We still, sure. Sorry, Jennifer. That's fine. Don't worry about it. So New England relies on natural gas for over half of our energy use, and I think it might even be 60%, and I'm looking at Dennis, so it is getting close to 60%. And that's actually before we have large-scale retirements of, I think it's about 2,000 megawatts of coal is going to be retiring in the next couple of years, and about 1,200 megawatts of nuclear, which either has retired or will retire very soon. Our peak load in New England is only about 30,000 megawatts, so it's a pretty significant chunk for us. So the states, ISO New England, our RTO, and FERC have all expressed concern about this reliance on gas. Adding to that, you hear a lot from the nuclear industry about the organized wholesale markets are not providing sufficient revenue for nuclear plants to continue operating. So we've been hearing that a lot. We actually have 2 nuclear units that have retired recently. A third, which is close to 2,000 megawatts, is also threatening to retire for economic reasons based on insufficient market revenues. So what does that all that mean? And how does this connect to the coal? Basically, if the coal starts going away out west, it means that the Marcellus shale gas, which we've become very reliant on, and we've seen our electricity prices drop by about half in the last 8 years or so, largely because of shale gas, that gas is going to start going out to the Midwest and to the West to start supplying the resources that used to rely on coal. So everybody loves competition as long as it drives down prices. And in the Northeast, we completely support competition. But once we start seeing the shale gas that we somewhat consider ours going west, we're going to see increased prices, and we're going to start having concerns about that. But in addition to the prices, it's actually the reliability that's a concern as well. There's only so many gas pipelines that go into New England from New York. And during many hours of the winter, especially really cold periods, there's insufficient gas pipeline capacity to provide all the energy that's actually required. So we've been relying on 60-year-old oil-fired units and a lot of the coal plants that are going to be retiring soon. So what are the states doing for this? We have a resource diversity issue. So what are we doing about it? States in New England are mostly focused on policies that drive new solar, new wind, intermittent, not providing any new baseload. So we have been looking at Canadian hydro. Good baseload power costs at least $1.5 billion to get the transmission line down, and nobody can agree on how to actually pay for that transmission line. Storage is still in the very early stages, and at least for the next 10 years, it's not going to be really economically viable as an option. So what we have been doing is instead relying on incentives to make the gas-fired units dual fuel units and to fire oil in the wintertime. Last year, that wasn't that big a deal because of winter was relatively warm and oil prices were really low. What happens if we have a situation 2 years ago, oil prices are high, temperatures are really high? We're going to start seeing increased prices again. So one challenge that we're seeing, and I'm going to try to tie this back to some of the discussion yesterday, is the structure of the organized markets. The organized markets have done wonders in terms of increasing efficiency, pushing risk away from ratepayers onto merchant plants, lowering prices. But they're also, by design, and for good reason, fuel neutral. So if states have particular policies, how can we get those policies that could include resource diversity? How do we get those to fit into the organized markets when the organized markets are specifically, they're not designed to limit those policies, but they're not always set up well. I think Jeff yesterday mentioned minimum offer price rule. So when you have a state contract for a particular resource, FERC or the RTO and then FERC will look at, is that contract an out-of-market, and can that contract be allowed to impact the capacity market? Usually the answer is no. So it limits to some extent the state involvement in what kind of policies we can push and how those get impacted through the wholesale market. So I think there needs to be a larger, broader discussion, not only about the impacts of what's happening out west and how does it impact other states, but also how does that then flow through to discussions on cooperative federalism? How can the states be working with the federal government to recognize that a federal policy over here is impacting state policies here, which then flow back through into federal markets? And there needs to be the discussion about how the state policies can work with the federal policies and how those all can work with the organized markets and how we can have better discussions with FERC. And with that, I'll turn it back to Miles.
That was awesome. I wonder if one of the questions that Ed's thinking raised for me was, let me just ask by show of hands, so those of y'all who are down in your BlackBerries, stick your nose up for just a second. How many of y'all have units that use that are either run on PRB, on Western low sulfur coal, or buy power from markets that have PRB running coal plants, just by show of hands? So there's going to be, so if federal leasing policy, so what I'm still unclear on is whether the leases are drying up because the coal companies are going bankrupt, or if the coal companies are going bankrupt and as part of that whole consortia of pressures, the leasing questions further constrain the ability of PRB to be a really cheap and available resource? Like, is the leasing issue further constraining PRB? And if it is further constraining PRB, then states that aren't Wyoming and Utah and Colorado are gonna be directly affected by that, and states that are Indiana and Kansas that aren't making PRB but are buying power that uses PRB will be pretty directly affected as well. So I still have to kind of like, I think an unknown for me is the relationship between whether a leasing constraint actually puts an additional constraining pressure on PRB as a coal resource vis-a-vis other coal resources. So let me pause at that. We've got lots of tents up. Tom Sloan from Kansas. Representative Sloan, what's your input to this?
I'm disappointed that Ed didn't bring ice cream. I want to revisit the leasing issue, but from a different perspective. I mean, there have been pressures on the agency for years that people thought that the amount of royalties paid or bonuses paid were too small given the value of the product. So I understand that that's sort of an underlying current. My question is more, how much policy collaboration between your secretary and the EPA administrator and the president in terms of we want to transition to lower carbon as a nation and therefore intercede both on the Clean Power Plan and from the BLM's perspective, maybe slow down the amount of coal that's mined. And so a two-pronged attack on carbon emissions.
Where's that hat I can put on? Yeah. No, I was thinking of the thank you, Your Honor. I don't have that information one, and I don't. I honestly don't know how much time the Secretary and the President and Administrator McCarthy have spent on this issue and what, if any, influence that had on the secretarial order. I do know that the order was not intended to constrain development. It was intended to make sure that the leasing that moves forward during these next 3 years is leasing that has either met the emergency leasing criteria or otherwise has already been through the NEPA process and we've got that signed record of decision. The intent is to make sure that this isn't having a significant negative impact on the market or on production. How that will shape out, only time will tell. But as far as your general question, I really couldn't speak to what was going on there.
Al Freeman from Michigan.
I think Al Freeman, Michigan. Another thing that I think we need to think about, and something we've had in Michigan is there's been some transition away from the automotive. Is if coal does go away, you're going to have a lot of people. That's how they made their money, or secondarily made money. And those people, how will those skills? Will they need to be retrained or brought back into the economy? There's a huge externality of the people who actually work for these companies and how they're going to be a part of the economy. It's wonderful if we have a clean environment, but if you have tons of unemployed people or can only get jobs at McDonald's from $30 an hour down to $7 or $8 an hour, that's frightening as well, and policymakers have to deal with that.
Noted. Commissioner Kane. Sadly, I think we are on the sharing plan, the buddy system.
Okay. That's right. I'm going to ask the question that Tom asked in a less polite way, which is I'm sitting here thinking we've got EPA, the end result of you know, the Clean Power Plan and a lot of the other things that they're putting in is you burn less coal. Okay, we've got DOE, which is working on quote-unquote clean coal and clean coal technology, and there's a whole thing there. And then we've got another federal agency, which is selling coal, and which is, yes, pausing it and looking at, but it's not clear to me whether the pause is so you get a better price for it, you control it better, you know, which is almost, and then we just signed the climate change, the international climate change, and we're telling all these other countries, don't do coal. Talk about backyards. You know, these are walls between backyards that we don't. So the question about, you know, where's federal policy going and what's it's trying to encourage, shall we say, states to do. It looks like the one hand doesn't know what the other one is doing, and I was interested. Question. I know you haven't changed that it's all now out for question about what should be in the NEPA, but does the current NEPA process and the environmental assessors look at where the coal that's being mined and sold to a Peabody or whoever, where it's going to be burned, what power plants it's going to be in, what impact is that going to have on the air quality there, or not?
Typically, no. Well, yes and no. The NEPA that's done for, I'll just say large scale for now, federal mining actions is really twofold when it comes to the upstream. We've got the EIS, or the environmental assessment that the BLM does, that's very specific to the mining itself. The emissions from the combustion of that coal is accounted for, but because we don't have any indication of where that coal is going to be going during the life of that lease, because oftentimes we're looking at 12, 15 years of production, and we know that contracts are only, you know, a long-term contract may only be a couple of years now. So we haven't been traditionally looking at where that coal is being burned, just how the coal is being used, in which case we typically say 100% for combustion. And then the Office of Surface Mining tiers to our document, prepares their own environmental assessment, and that's the same idea. They're looking at that local effect for the most part. But that's, you know, you brought up a very good point, that we're kind of at this this very interesting and kind of exciting juncture on one hand, that we haven't had a hard look at the federal, or at least the BLM's coal leasing program in over 20 years, and I think there's a lot of modernization that we can reasonably do that will help industry, that will help account for some of the environmental concerns, and can do it in such a way that doesn't come out looking so onerous that it's just you know, you throw your arms up in the air and say, why did we do this? I think that's the important part of this scoping process, is to get those comments and to get that direction from the public and the states and the stakeholders that say, these are the things that we really need to look at, and these are the things that are going well. This is what you're doing right, so that we can really focus things down and say, okay, here's the direction that we need to go, and here's some of the things that we need to address for the next 20 years. Did that even answer your question?
Yeah, to some extent it does, yes. And I'm thinking also, did Joe mention the NRC? You know, I mean, as national policy, do we encourage coal? Do we make it easier to mine? Or do we make it easier to have nuclear, which is cleaned? Which is not the question to ask Vermont, because they have closed down nuclear. But you know, when you talk about baseload and reliability, who's looking at this at a national policy level, both from reliability and from air quality, et cetera, at say coal versus nuclear, and what are the agencies doing in their own silos that would support or inhibit looking at that? And
I have absolutely written that down. That's a great point. I do have one question that's, I don't know if this is, it's maybe two questions, and it's maybe directed almost rhetorically. My first question is are we looking at a postcard from the future for gas? Does federal lands play a big role in where we get gas? And are there things that should we watch this game pretty close to see what the plays look like as a potential kind of indicator for something that could happen in a future where carbon constraints come even more, tightly to start affecting gas? So I think my saying that seems to have scared up some cards. Darren, who's down there? Margus and Catherine. Well, let me let the ladies go first. Really, Marcus? Your card's been hiding behind a water thing. You need to be...
Sorry.
It's the water energy nexus. It's
that
the
right
word.
here in action, yeah. This is Marcus Hawkins, Wisconsin Commission. I also want to react to what Miles just said, because that kind of sparked something. But first, to what Ed was saying, coming from Wisconsin, that sounded like a glowing endorsement for long-term planning and vertically integrated utilities, and with your fuel diversity issue, which I appreciate. But I had a question about the dual fuel requirements. Is that being driven by the states or by ISO New England stakeholders primarily, and how has that been working its way into the market?
So first, Vermont is the only vertically integrated state still in New England. That said, and I will get to the second part, I think that there's always this dichotomy of either you do planning or you do markets. And I think that's just false, because markets are sort of, it's not like they have a mind of their own. They're structured. They can take into account different policies and some aspects of planning, and should actually. But anyway, so moving on to the dual fuel units, that was something that ISO New England actually proposed through the stakeholder process. FERC accepted as an out-of-market, basically subsidy to allow existing dual fuel units and oil units, actually just straight oil-fired units, which we still have a lot, I think 10,000 megawatts or so in New England, something like that, to actually buy the oil. At first it was you buy X number of barrels of oil in the winter, and then it was you get reimbursed for whatever you have left over to make sure people continue to fill the tanks all winter. But that was actually passed through the wholesale market. So it was the states had supported, I think all the states supported the out-of-market payments, but it was driven largely by ISO New England.
So qualities next to godliness. The next two folks who are talking, make a comment, don't ask a question. Or if you have a question, you have to address it at the break.
Catherine Morris with Consensus Building Institute, and I wanted to follow up on the comment you made about the jobs impact, and we'll follow up with a question later. But I think another silo that is sort of being set up right now is the whole silo of money being poured into Appalachia and the West through the Economic Development Agency and Appalachian Regional Commission to try to address the problem of the economic distress being caused in those regions from the loss of jobs and the downturn in coal production. And I'm assuming that that's one of the issues you're going to be looking at as you look at the socioeconomic impacts on a programmatic basis of what is this going to mean long term if the market drives production down. How are we going to address that long term? Because I think everybody agrees that the money that's being pumped into that now by the federal government is not going to be enough in the long run.
Thank you for framing that with a period at the end instead of a question mark. Darren.
Thank you, Darren Carney, South Dakota Commission staff. Just to respond to Miles' point, I think that gas isn't next on the chopping block. I mean, Sierra Club just went from the Beyond Coal campaign to the Beyond Dirty Fuels campaign. And so there's going to be a lot more discussion in the future around fracking and, you know, how you account for that, any externalities associated with that in the environmental impact statement. I also wanted to note that when you're talking to EISs, I think it needs to be specific to the process or what you're looking at, right? So if you're mining, it should be specific to mining and not take into account externality costs associated with emissions, because when a power plant gets sited, it has its own environmental impact process, and that's where emissions factor into the NEPA process. Basically, if you're putting a carbon cost on the production as well as the emission, you're double counting the carbon costs. So I guess you have to kind of be careful there. And I mean, ultimately, if you want to get rid of coal, then yeah, you choke it out by adding all these costs to production and manufacturing or burning it. And then the next fuel source, gas, will follow similar suit.
Point well made. Won't y'all join me in thanking Alfred from BLM for coming out and talking to power folks, which is not his bread and butter, and for, to Ed for leading off our discussion on coal leasing, which is not exactly Vermont's main dairy alternative. Thanks to both of y'all. We're going to move beyond this session to a 15-minute break. And
before you wrap up, I just want to say I've heard some really good comments today, and I would really love to encourage all of you to supply those comments to that website in writing as something that we should consider in the programmatic environmental impact statement. That would be really helpful to tee that up. Thank you.
All right, we'll get started again at 11:15. Please feel free to move about the cabin.
About 5 more minutes before we reconvene. Apologies, I had that wrong. We're reconvening in about a minute. Okay, everybody's got their coffee. We're back in place. All right, our next topic is one that I think will engender quite a lot of discussion, and I hope that we will really get to that point of this session where we talk about information gaps that exist in the blurred lines between federal and state jurisdiction on transmission planning and transmission construction and so forth. We are very pleased today to have Jennifer Murphy from NARUC, Chris Lawrence and Sam Walsh from DOE, and Kim Jones from the North Carolina Utilities Commission providing the first responder role as we start off on this discussion. So without any further ado, I'm going to turn the program over to Jennifer Murphy from NARUC.
Thank you. Thank you very much. So we're continuing on this theme of the changing electricity sector. We thought this would be a good opportunity information we need to understand those implications. With us today to flesh out the issues and explain DOE's role are Christopher Lawrence, an electricity policy analyst in the Office of Electricity Delivery and Energy Reliability at DOE, and Sam Walsh, Deputy General Counsel of Energy Policy for DOE. Then Kim Jones, a senior electricity analyst with the North Carolina Utilities Commission, will discuss the stakeholder aspect of transmission planning and issues of eminent domain. So I'll turn it over to Christopher Lawrence and Sam Walsh. Thank you.
Can you hear me well? Well, thank you, Jennifer, and thanks for the opportunity for us to speak about this. So the story of this project begins, as Jennifer indicated, with the Energy Policy Act of 2005. EPAC 2005, and that statute contained, as probably some folks here are familiar, a number of provisions intended to facilitate and accelerate transmission development in the United States. You had Section 1221 of EPAC 2005, which had the backstop site authority provision. You had the second half of 1221, which became 216H of the Federal Power Act, which was intended to accelerate federal permitting of transmission facilities. You had the provision that became Section 217 of the Federal Power Act on rate incentives, and there are a few others as well. Section 1222 was a new authority that authorizes the Department of Energy through either the Western Area Power Administration or the Southwestern Power Administration, or both, to partner with private developers in the design, development, construction, ownership of new or upgraded transmission lines. And what was, now of course Western and Southwestern had pre-existing authority to construct transmission lines. What was truly new about Section 1222 is it authorized them to do so for transmission lines that were not intended to deliver federal hydropower, and gave explicit authority to partner with private developers and accept contributed funds for that purpose. Our understanding of kind of the idea and sort of where the idea for it came from was from the it was kind of inspired by the Path 15 upgrade that took place in the sort of 90s and early 2000s, where you had Western Area Power Administration that was directed by Congress to partner with private developers, accepted private funding from those developers, and did land acquisition and succeeded in getting that line built, and did not go through the California regulatory process in doing so. And that was, you know, as we understand it, widely regarded as a success, and so something that sort of Congress may have been looking at when they wrote Section 1222. The department put out a request for proposals under this provision, 1222, back in 2010, which kind of sort of invited the world to file applications with us, said a little bit about the evaluation criteria that we would use in considering applications. We received later that year an application from Clean Line Energy Partners for what they called the Plains Eastern project, which at that time was 2 HVDC lines running in parallel with a kind of unspecified eastern terminus. We sent it back to them and said, this needs more development, and they came back the next year with a refined proposal that had a single HVDC line with a specified terminus. The department considered that application for a little while, and then in 2012 decided to initiate NEPA review in order to kind of arrive at an ultimate decision on whether to participate. The NEPA review process took between 3 and 3.5 years.
Sam, could you clarify for me? When you say private development, mm-hmm. does that mean an entity that is a non-utility private development, or does it mean it's an investor-owned utility, which is could be a private development? It doesn't mean a public utility, a co-op or a muni, but those two other terms. What does private development mean?
I guess I was using that as an umbrella term for a kind of non-federal partner. The statute doesn't specify, and it could be any of those that you mentioned. So we conducted NEPA review beginning in 2012. In 2014, it became clear that we would need an additional process to consider not just the very significant, environmental and cultural resource impacts that were being studied in the NEPA review, but also some of the considerations that Congress directed us to think about in the statute itself. And so we required Clean Line to update their application, which by that point was several years old. And we took that application, put it on our website, opened it up for public comment for ultimately 2.5 months, which is a good long time. And we got about, I think, 700 comments in response. So we had a record between the application itself, the information generated in the NEPA process, and the substantial volume of public comments. The NEPA process concluded in the late fall of 2015, and the department ultimately, in March of this year, announced this decision to participate. We have on our website what we call the summary of findings. It's about 70 pages, and it sets out in some detail kind of some of the background that I just described, but also sort of the reasoning behind our decision. To kind of like, you know, spoiler alert, the most significant reason for the department to participate in this project was that it facilitates development of renewable energy in the Panhandle region at gigawatt scale. This is a project that can deliver 4,000 megawatts of wind energy from the place in the United States where it's some of the lowest costs, most consistent average wind speeds in the United States. It would deliver to a intermediate converter station located in Arkansas, as well as on eastward into Tennessee. In addition to the summary findings, which sets out all of our reasoning, we also put out on our website our agreement with Clean Line, which is unusual for a government agency to do. We typically do not put out, you know, contracts and agreements that we enter into like out for public viewing. But in this case, we thought that the kind of benefit of being able to transparently communicate to the public exactly the terms on which we were participating in this project was very important. And so a few things about what's in that agreement, because it's sort of impossible to understand kind of what we've signed up for without kind of getting into some of that detail. And I also understand that we may be standing between you and lunch, so if at any point you just start banging on the table, we'll know to wrap it up. But if you will indulge me, I'll talk a little bit about kind of what the nature of our agreement was. I mean, the Department of Energy's role is principally, and this is set forth in more detail, but principally to handle land acquisition and oversight responsibility for some aspects of construction and regulatory compliance. The Southwestern Power Administration will have an important role in carrying out these functions on behalf of the Secretary of Energy, but as we emphasized in our summary of findings, and will continue to emphasize at every opportunity, the Southwestern is not playing a financial role in this project. Were there any costs or unrecovered obligations associated with this project, it would be, in our view, legally impermissible to attempt to recover any of those costs in the rates that Southwestern charges for federal hydropower. We have a kind of lengthy explanation in the summary of findings about how Southwestern's rates are governed by the Flood Control Act, and that act makes no allowance for recovering costs associated with the 1222 project. I'm looking around the table. I don't know if we have Southwestern states represented here, but I think that's been an important issue over the kind of life of this project, and that's why we emphasized it. So another important aspect is that this is not a financial assistance authority, that all of our costs, all of the Department of Energy's costs, are paid for by Clean Line in advance. They've also agreed to indemnify and hold us harmless against any liabilities that we could incur associated with the project or associated with our role as owner of land and assets. That indemnification obligation is backstopped by multiple forms of financial assurance, insurance coverage, letters of credit, etc. Another important aspect of the participation agreement is that the department has calibrated our participation in this project based on Clean Line meeting commercial and technical milestones. So, and this is important because it kind of relates to the familiar chicken and egg problem associated with transmission development, which is that while we have made a commitment to participate, our commitment is conditioned based on conditions precedent that have to be satisfied by Clean Line for every next step that we would take. So before we would engage in any land acquisition, even voluntary arm's length negotiation for land, Clean Line needs to satisfy a set of conditions precedent. I'm not going to list them all now, but the most important one is that they have to have firm commitments for over 1,500 megawatts of transmission capacity on the project. There are actually multiple sets of conditions precedent. The next one, and the only other one I'll mention, is that before the department would use eminent domain, because as we've said many times, that we regard the use of eminent domain as a last resort, something to be minimized. Before we would use eminent domain, the Clean Line would have to demonstrate that they have financial commitments to pay for all project costs, and that's of critical importance, right? We want to make sure that they've sort of passed that they've done everything possible to ensure that the project is viable commercially and likely to proceed commercially before we would use that power. The couple other important details. So we have required Clean Line to pay in our agreement with them to pay local taxing authorities in the states that the line traverses to make payments to them for assets and land that's owned by the federal government that would otherwise be taxable. We think this is an important step. They were willing to do it, and we decided to kind of lock that commitment in contractually. And so if you go into the agreement, it's on our website, you can go like county by county in Oklahoma and Arkansas and see what kinds of payments the counties anticipate to get based on the current estimate of the mileage in each county. We also insisted upon what we think is a very kind of rigorous set of landowner protections. So the way land acquisition would work would be that first Clean Line would attempt to acquire every parcel itself. In doing so, we've required them to follow the procedures that federal agencies have to follow when federal agencies acquire land. It's based on a statute called the Uniform Act. It's kind of a shorthand name. And which it has a lot of kind of procedural protections for landowners in it. For any parcel that Clean Line was unable to obtain going through this process, the department would obtain, and we would then ourselves go through that Uniform Act process again, starting from the beginning, starting from appraisal and arm's length negotiation. But for Clean Line's part, in addition to going through this process, we have in the agreement with them a kind of set of minimum offer requirements that they have to make to landowners that we think go beyond what is typical in this space. And we've also required them to submit to binding arbitration on price with any landowner that is willing to sell but has a disagreement on price, which we think is a significant protection. So let me stop there and hand it over to my colleague Chris Lawrence, who's going to talk a little bit about Office of Electricity and some of the related transmission authorities.
Okay, thank you, Sam. Again, thank you to Miles, Jennifer, and to Carrie for inviting us here today. My colleague Caitlin Callahan already told me that Miles made a Robin Thicke joke yesterday about blurred lines, so I'm going to spare you of a joke then. Thanks a lot, Miles. So anyway, let me just kind of give a little bit more context over where the 1222 program fits in to the department's role here. So my office is the Office of Electricity Delivery and Energy Reliability, which may be familiar to many of you sitting around the table. OE is charged with, its mission is grid modernization and also resiliency of the grid. We are pretty agnostic on, you know, the points of, you know, energy in general, where the energy is coming from, but we are, our mission is to ensure that whatever the energy source is and whatever the demand is, that the grid is able to respond to those challenges. We have several divisions within OE. We have the Infrastructure Security and Energy Restoration Division, which my colleague Jeff Baumgarter is representing here today, that handles energy emergency preparedness and response. We have Research and Development Division, and we have my division, which is the National Electricity Delivery Division, or NED for short, which is a very catchy name. We have multiple authorities of which we execute. The 1222 program is one of them. Other authorities that we have are under an executive order 10485, which gives the department the authority to issue presidential permits for the construction, operation, maintenance, and interconnection of international transmission lines. So we are currently reviewing several permits, mostly from Canada into the United States, and mostly from Canadian hydropower into the United States. With that, we also have the accompanying program, which is under Section 202E of the Federal Power Act, which says that the department issues export authorizations to export electricity over those transmission facilities, of which right now we currently have several applications outstanding, mostly actually exporting to Mexico. In addition, Sam had mentioned it, Section 1222 of EPAC established Section 216H of the Federal Power Act, which says the DOE is the lead federal agency to coordinate transmission permitting for projects requiring multiple federal authorizations. Underneath that, we signed a memorandum of understanding in 2009 with several other federal agencies, colloquially known as the 9-agency MOU, because there were, you guessed it, 9 agencies that signed it, that said that we, how we're going to coordinate the review of these transmission lines that require multiple authorizations. BLM is a signatory to that. And DOE actually recently, using that authority, issued a notice of proposed rulemaking in February for something that's known as the Integrated Interagency Pre-Application Process, which is not as bureaucratic as it sounds, but basically allows for a pre-application procedure for these transmission projects that require multiple authorizations, saying basically recognizing that entities that wish to apply for these authorities, it's probably better to come in to and discuss this with the agencies and stakeholders prior to actually coming in with a formal application. That notice went out in February. That period closed in April, and we received 11 sets of comments on that. That was all led up. Prior to that, we had issued a request for information, under a draft process that we had issued. In addition to all of those responsibilities, we also handle what's called our Electricity Technical Assistance Program. Caitlin Callahan again and Matt Rosenbaum from my office, who are back there, also administer that program, that we basically work with state commissions and other stakeholders to evaluate different emerging issues that are coming out in regards to electricity regulation, and we provide grant and funding and other assistance with that. So I'm going to stop there as well and hand it over.
Kim Jones on the regulatory staff in North Carolina, and Carrie Worthington called me about a week ago and asked if I'd provide some reactions from a regulatory agency perspective on the Section 1222 project, and specifically the Eastern and Plains and Eastern Line. One of my bosses, Chairman Finley, is here today, and I'm sure he will echo that the comments I make are purely my own, and like a James Bond or the Mission Impossible movie, he'll disavow. And
to set the stage, you know, thinking about this from a regulatory agency perspective, I'm going to have to draw on and be informed by my experiences through life, and I'm going to share some of this with you because it's an odd trajectory, actually, how often I keep bumming into transmission stuff. So I'm going to share a few anecdotes. I hope you'll bear with me. Maybe you'll think it's a little over the top. The main issue raised by this project is, from my perspective, eminent domain and the people impacted. So that should not come as any surprise to you. But I don't think there's anybody in the room who shares my Minnesota, land of 10,000 lakes and 20 million cottages around the lakes. So this may be new old history for you. There we go. So back in the late 70s, up in Minnesota, two G&T co-ops, United Power Association and Cooperative Power Association, and they have since merged into one, but they're G&T co-ops, pursued a high voltage DC line that went from a North Dakota coal plant down to near Minneapolis. And at the time, this project really dominated the headlines, and you'll see why in just a minute. The public sentiment against it was about the most intense I've ever seen. It was so intense that in June of '76, farmers communicating with each other with citizen band radios began blocking the surveyors who were working on the project, and law enforcement officers had to accompany them. Farmers put up roadblocks and used tractors to pile boulders around the tower bases to prevent concrete pours. So that's in June of '76. Fast forward to January of '78, quite a while later, protesters dismantled part of a tower in full view of state troopers. Governor Rudy Perpich ordered what was at that time the largest mobilization of state troopers in state history. More than 200 state troopers, almost half of the Minnesota Highway Patrol, were called into action. In March of '78, so this is over a period of years, it was quite unpleasant, over 8,000 people marched in protest. In August of '78, a group calling themselves the Bolt Weevils began to sabotage the power line towers and shoot out insulators. The G&T co-ops hired outside security officers to patrol the lines with helicopters and vehicles. All told, 20 towers were toppled, nearly 10,000 electrical insulators were shot out. Nevertheless, the line did get built, and it was energized in August of '79. Now, I offer this not as a prediction, but as a cautionary tale of how bad things can get when policymakers aren't able to successfully balance all the interests. And I'm not asserting that that's what's going on here, but there are a few cautionary aspects. To complete your history lesson, political science students at Minnesota's Carleton College had a front row seat on this action because their professor, Paul Wellstone, personally engaged in the controversy, and I understand my mother is recalling that he actually climbed a tower and got himself arrested. He eventually wrote a book entitled Power Line, The First Battle of America's Energy Wars. He went on to become U.S. Senator and was perhaps the most liberal U.S. Senator in all history. And he died tragically in an airplane crash in 2002. And my 23-year-old daughter is convinced that it was a conspiracy. She's also a Bernie Sanders supporter. So I went on to work for the power company, which was Northern States Power at the time. And memories of the UPA-CPA power line did not fade quickly. And in the 90s, one of my tasks, I did regulatory relations at the time, was to go to state government and let them know we needed to build a power line from North Dakota and to Minnesota, and again cross that border. At that time, Rudy Perpich was governor again. He had appointed his brother Tony to be the head of the main consumer advocacy agency, the Department of Public Service. And what a cold shoulder. I went in to tell him we really need this power line, and basically the answer was no way, it's not happening. And luckily in that case, the transmission planners had a plan B, which was, I think, a static VAR compensator, fancy thing, that looks like a big substation. And they were able to
put together a Band-Aid that worked for quite a while. Since then, a real line has had to be built, but it bought some time. So today in Minnesota, I think there's a lot of transmission getting built. People see the benefits of hooking up the wind machines, and this kind of legacy has sort of melted away. But it stayed with me because I'm the one who had to come back and say, Perpich isn't going to change his mind on this. So fast forward. 2006, I moved to North Carolina, got the job with the North Carolina Commission. My husband and I bought this nice house in Raleigh. In 2013, a few years later, we wanted to sell this house and downsize. But across the street is a big bunch of trees, and behind the trees is a power line. Now, there were several potential buyers who backed out, and I'm convinced it was because of the line. It was also a really bad time in the market. Be that as it may. Also in 2013, this is the fun part, my son Ben moved in with us for a while to attend a lineman's training school in Rocky Mount, North Carolina. And I'm very proud of him. Only 40 guys started this program and only 7 graduated. It was pretty intense. You got to really want to do this work. Today he's working as an apprentice lineman. He's one of those nomads who travels from construction project to project. Right now he's on one in Iowa. But after just 1 year as an apprentice lineman, he was able to afford a very nice house, as nice as Mom's house, okay? So when people assert that building transmission has economic development that there are jobs related, yes. And everyone is always happy to see their children launched. So this is good. And I can also tell you that there are many projects that are absolutely needed. Back in the day with the power company, my last role there was in the transmission business unit, and I helped make the case for a 230 line from Devil's Lake to Canada. In fact, I came to visit your predecessors and said we're going to need one of those presidential permits, and made the case internally to get the money. I didn't work on the project out in the field, but I did have the satisfaction a year or two later after it was energized. There was a horrible, horrible ice storm that took down a lot of facilities, and the control room operators told me that that line was the only thing keeping the lights on in North Dakota. And so it does matter. I get it, okay, that it's hugely important. Balancing the public interest is just tricky. So here we are today. Talking about a specific power line that I've only been researching for about a week or 10 days in my spare time. So I'm going to give you some reactions, but please bear with me that they may be just a tad half-baked. And I noticed we have one gentleman here from Kansas. So if you know more about all this stuff, please don't be shy. But I don't think there's anyone here from Iowa or Missouri or any of the other states. I'm sorry? Some on the phone. Some on the phone. Okay. So hopefully I don't misrepresent the history and can set me straight.
Kim, if I could just add there, the department's participation in this project would be just in the states of Oklahoma and Arkansas. So.
Understood. So continuing on in kind of the news of the weird transmission in Kim Jones's life. So I do have to say that the Clean Line Energy people really have an awesome website. And if you go on their website, you can see the route. You can plug in an address and exactly see how this route relates to any specific parcel of land, and that's what I did. So I ask you, what are the odds that I plug in the Annie's Chapel, which is a cemetery in northwestern Arkansas where my grandparents are buried, my great-grandparents, and my great-great-grandparents. It's pretty important place in my family's legacy, and the route is about a quarter of a mile to the north. So in this photo, and it's not a very good one, but if you've been to northwestern Arkansas, you know it's absolutely beautiful. It's the Ozark Mountains, okay? And they aren't literally mountains like in Colorado or in North Carolina, but the people there love them, and they're covered with trees, and so it is quite beautiful. So clean lines, and we're going to hone in on Plains and Eastern in a second, but from the regulatory standpoint, there are a few trends that I might bring to your attention. So they've got 3 projects. The Rock Island, which would go from western Iowa, I guess, over toward Indiana. The Grain Belt Express from Kansas through Missouri, again to Illinois, Indiana. And then the one that's the focus of today, the Plains and Eastern, Oklahoma through Arkansas into Tennessee. 3 projects. What's interesting is to see how they're progressing as a group, and you can start to see some trends. Now, in Arkansas, in 2011, the Clean Line Energy sought status as a public utility, and the commission there said no. And a strict reading of their order, it sort of has the flavor of you can't be a utility because you're not a utility, kind of. It was a little bit circular. But it is what it is. In 2011, they turned them down. In the Grain Belt Express, the one slightly to the north, in July of 2015, the Missouri Commission denied that project a certificate of convenience and necessity. However, Kansas, to the west, where I'm assuming the windmills are, said yes. And then Indiana and Illinois, to the east, said yes. So you've got kind of the pickle in the middle here, Missouri. Further to the north, you've got Iowa with the Rock Island project. They're sort of in the middle again. And they are debating in their state legislature, well, April 6th, so quite recently, and maybe they're done with their debate, I don't know, but a piece of legislation that would slow down or put restrictions on that project. This one radio station says the bill faces an uncertain future. Opponents say it would derail the $2 billion transmission project, but it would also derail $7 billion of wind turbines. So there's a lot of tension there of what direction does Iowa want to take. You know, are they willing to put up with another power line in order to get more wind development? So they're literally kind of stuck in the middle. Okay, I'm going to switch gears now to the Plains and Eastern. As the previous speakers mentioned, in March of this year, DOE announced it would use its authority under Section 1222 of the Energy Policy Act of 2005 to directly participate. This means that Clean Line Energy will provide the cash, and DOE will provide the eminent domain authority and own the project. At the same time, DOE issued the completed environmental impact statement required under NEPA. Now, the little bit I've been learning about this, I kind of swiveled in my chair to my colleagues at NARUC who do the legislative lobbying, and I said, okay, do you remember this 1222, and did NARUC take a position? And they said basically when they read the law, it didn't seem all that ominous, and they were busy focused on the backstop siting. And if you read 1222, it does not use the words eminent domain, and it does not directly say that the DOE can avoid a state construction permit or that DOE can itself do the routing. It does not say that. But in the document that Sam mentioned, and I'll give you the web link later, this document, their summary of findings and applications, they do explain the rationale. And I'm not an attorney, so I'm out of my bailiwick. There's something called the Condemnation Act, pre-existing federal law, that I guess says that if a federal agency has the right to own or acquire or build, by definition they have the right to acquire the land, which by definition means they can use eminent domain. So it's a little bit of a link back to this other law. So the NARUC staff was not paying attention at the time that it passed. They were busy focused on other things. This isn't a very good map, but it gives you a little bit of a sense. 1222 gives DOE the authority in 2 big areas of the United States, the WAPA footprint, which is the pink, and the SWPA, Southwestern Power Administration, which is the purple. So if I were in Missouri right now, I might have a few questions for the Department of Energy as to what their plans might be, because they seem to be kind of right in the target zone there. Arkansas's congressional delegation, it's not a very big one. They only have 4 congressmen and their 2 senators. In March, came out with a joint statement saying that they saw it as executive overreach, that the same private company that Arkansas had denied rights to is now teaming up with the DOE, and that they didn't see that as right. So, and perhaps this, others maybe not share this reaction, but one of my reactions was, it looks a little goofy, the optics of having the Department of Energy both be a partner in this project and the regulator from the NEPA point of view. That just, for me, grates a little bit. And like on this slide is where I provide the link, and it really is interesting reading. If you have any interest in transmission, I really think you should take a look at it. But it explains how the project would meet the requirements of Section 1222, concludes that the project is in the public interest, essentially because there is wind power potential in Oklahoma and the Texas Panhandle that does not have access to transmission. There is nothing really that I could see that says electricity needs are growing, or that there are people who want to buy the power. It is, there are developers willing to develop the power, is really the gist of it. Let's see. So I think this is really where the rub is going to come for this project, and whether at the end of the day it actually gets built, is whether there are either markets or individual utilities in the east who want to buy the power. It seems like there are many willing wind developers, but maybe not so many buyers. And maybe things have developed since the document came out. And then the converter station in Arkansas, and this is where my little bit of background in transmission. So the wind generators are in Southwest Power Pool. Arkansas itself is kind of split between Southwest Power Pool and MISO. MISO and SPP both already have a lot of wind, and they're already struggling with wind intermittency issues. So I understand that putting the converter station in Arkansas to offload some of the power there is intuitively feels like the project is contributing to Arkansas. They're getting some benefit, but the fact of the matter is I think it's a benefit that has little value to them and might be more trouble than it's worth. You're not kicking the can very far down the road. So I can see how you got there, but I'm just not sure it's worth the trouble. Now, the Sierra Club, for example, has come out in support of the project because of their support for clean energy. But there are opposition groups. This is just one. Johnson County, the county where that little cemetery is located, their county commission has a resolution, and I suspect every county along the route has a resolution. The bill in Congress, I understand that last week during the debate over the Senate energy bill, there was an attempt to amend it and change this provision, and that it, well, this is the act, a bill, it isn't an act yet, that was proposed by the delegation out of Arkansas. Basically, it would say the project under 1222 could not use eminent domain unless the governor and the commission of the state agreed, and that to the maximum ability possible, federal land rather than private land should be used for these projects. So last week when the Senate energy bill was being debated, there was an effort on the Senate floor to amend it that failed by a vote of 52 to 44. So there was some support for looking backwards and unwinding this, but not enough. So in closing, I just want to note that back in the land of Minnesota and ice where things got really nasty, there was a governor who was willing to call out the troopers, and in fact that project had a certificate of need. It had a state-approved route. So despite that state support, there were many citizens who took fairly drastic actions I don't believe anyone was hurt, but at least I think 4 people were convicted of crimes, one of them a felony. The project was delayed, and the costs were certainly higher than they would have been otherwise. If the Plains and Eastern Line does move forward, many of the construction jobs, by their very nature, will be filled by people like my son, people who with specialized skills who are brought in from other states. And local unrest over the project could make it difficult for these people to get their jobs done. Policymakers owe it to them and our citizens to work through these contentious issues and try to make decisions that address everyone's concern. And for a lot of agencies that have to do this routing eminent domain thing, I think a lot of times they wish it was somebody else's job. But in general, I think the closer you are to the local, the better the odds are that you'll be able to find that right balance.
Thank you, Kim. Before I open, okay, we have some questions. I just didn't know if the gentleman from DOE wanted to make any comments first.
Yeah. Well, first of all, Kim, thanks so much for your perspective. That was great. I'll just address a few things that came up. One thing, just that made me bristle a little bit. Want to set the record straight. You suggested that there might be some sort of conflict from the fact that the department did the NEPA analysis for a project that we are involved in. That's how NEPA is designed to work. It's a statute that requires federal agencies to review and analyze the potential environmental impacts of their actions of programs and projects that they are themselves going to be involved in and undertake. That's how it's set up, and so doing so for this project is really kind of a course. Second, about kind of demand for the project, points well taken. We think, as for reasons that we described in the summary, that there are good reasons to think that there's demand for this project. However, I just want to go back to one thing I said in our opening remarks, which is that our involvement is really conditioned on firm transmission agreements being in place, right? So we're not going to go out into the field until that's happened. Third thing, which I didn't mention in opening remarks, but I think there's emphasis, is that this is a merchant project. So every utility, everybody who goes out and buys capacity here has made a business judgment that this is a good value to them. And so with respect to the Arkansas converter station, your comment that it might be more trouble than it's worth, well, there will be ultimately a market test there. The utilities that may or may not purchase capacity on that converter station will have to make a judgment as to whether it's more trouble than it's worth. You're correct that there was an effort to amend legislation last week. The amendment would have required the department to submit an additional report associated with projects undertaken under 1222. I believe it got 42 votes in support, so quite a margin away from what they would need. And lastly, I just want to thank you for calling attention to these landowner impacts. It's obviously something that is of paramount importance for projects like this. We consider that a great deal. A few thoughts, though, just to add to it, which is one is that this is as a high voltage DC line. While this project itself will surely have impacts on landowners, it is, from a land use perspective, one of the most efficient ways to kind of transmit large volumes of power from areas where the wind is strongest. And one thing we pointed to in our summary of findings is the fact that Southwest Power Pool conducted a study that kind of assumed you were going to export 10 gigawatts of wind out of the SPP footprint eastward, and they built two kind of optimal baskets of projects in order to achieve that result. One that was only AC and one that mixed DC and AC lines, and they found ultimately that the bundle of projects that included DC had 40% fewer transmission line miles. there's a sense in which, while clearly individuals will be impacted by any particular project, and that is very important to bear in mind, but there's a sense in which projects like this, high voltage DC projects, have the potential to minimize aggregate impacts system-wide.
Thank you. Okay, I saw Darren first. Oh, or Marcus. Marcus.
Hi, thanks. Marcus Hawkins, Wisconsin Commission. I just had a couple comments from Kim's, what I thought was a really great presentation. But on the MISO wind integration piece, I don't usually compliment MISO all that often in my job, but today I will. I thought they've done a really good job of integrating a very large amount of wind. I believe they just surpassed 15 gigawatts of wind this past year. But that's all primarily in Minnesota and Iowa, and so the Arkansas piece within MISO and all of MISO South, I believe there's 0 megawatts of wind. So I see that substation in Arkansas as an interesting opportunity to spread the integration of wind throughout the entire MISO footprint. And granted, I am very far from those local land impacts, so that's just my perspective from Wisconsin on that.
Thank you. Darren?
This is Darren Carney, Commission staff, and I should have precursed all my comments that these are my own comments, not the comments of the commissioners or the state of South Dakota. So Kim Jones reminded me I should probably throw that caveat in here. So anything I said today are my own thoughts and comments. But for this, I'm curious, is this route along one of the corridors of national interest that I think a FERC order established? Is it order I can't remember what order it is, but they developed like these national corridors of interest, and right. Is this project along one of those routes?
So actually it was in section 1221 of the Energy Policy Act that established actually DOE has the authority to create those or establish those national interest electricity transmission corridors that would then give FERC the backstop authority that you were talking about. This is not along one of those corridors, and those corridors actually there's actually none that are actually established due to some tricky court proceedings that David Meyer to my right here could probably talk to you more about.
Then I have another question, and I believe from Kim's remarks, it's the project is based on potential supply opportunities. In South Dakota, we have a lot of wind developers going around trying to tie up rights, landowners' wind rights through easements of various terms and whatnot, and ultimately it can't get built unless the transmission is there. But I'm wondering how a developer and like a FTR or like a reservation on the transmission line works, because they're not going to go forward with the project unless they have a buyer, right? If I'm potentially developing a project, I could have land and I could get reservations on a transmission line without a buyer for the power. And I'm wondering if they can back out of those transmission reservations if nobody ultimately ends up buying the power, which they would ultimately need in order to get financial backing. They need a PPA in order to build the project.
Well, so Cleanline did have an open season for this project, and they entered term sheets for precedent agreements of, I think, over 8 gigs. Before they, I think that to satisfy our conditions precedent, the transmission service agreements that they enter have to be firm. There are no outs. I mean, and in practice, that will mean, I think, that you'll have to have firm PAs underneath, like lying behind every transmission service agreement.
And one last comment, is the DOE concerned about any precedent this establishes? Because there's a lot of wind potential, North Dakota, South Dakota, where we're transmission constrained, and I know we got developers that would be interested in it. So if another transmission developer comes along and pitches a project and say, you approved or you supported this project down in Oklahoma and Arkansas, why wouldn't you back a project going from the Dakotas to the east?
Thank you. Tom Sloan.
Thank you. And Kim, I've worked closely with the Southwest Power Pool. They've done a good job of integrating the wind too, and you know, they have seen, as you noted, that long-term development of the wind capacity in the Panhandle of Texas, Oklahoma, Kansas, and on up into the Dakotas now that you have seen the light and you know, joined the Southwest Power Pool, lies in moving to the multiple coasts, be that the Great Lakes coast, the Gulf Coast, or the Atlantic and Pacific Oceans. But I think the larger issue is, as Kim noted, there are 3 proposed clean line transmission line projects. Most of the states have given approval for clean line to be considered a utility and therefore have eminent domain and other rights. They have frequently not been very good in dealing with the property owners or landowners. There have been a lot of contentious. In fact, even though they have permission in Kansas to construct their line, the Kansas Farm Bureau members were so upset they got the State Farm Bureau engaged. They killed some legislation that I was trying to pass. It had nothing to do with the clean line, but they associated it with it. And the Kansas Farm Bureau then went to Missouri, Indiana, and Illinois Farm Bureaus saying, you really need to energize there too. So I guess my only caution to the department, because I think it's good that you're engaging, is to hold clean lines feet to the fire on their landowner relations.
Commissioner Finley?
Yes, in Finley, North Carolina. This is one area when you talk about taking private property interests from property owners where the line really does get blurred, and it's the property owners would very much like to have the local authorities determine whether or not they've got to give up their property and how much is paid for it. National interests, statewide interests are very much concerned about moving power from one place to another. It's going to be it's always been a contentious issue. It will continue to be more contentious because those who are against fossil fuel will intervene and try to prevent the construction of transmission lines in order to make sure that fossil fuel generation is not transported from one place to another. It's interesting that some of the environmental groups seem to be supporting this line, which is moving renewable power, wind power. They would be very much against this line if it were moving fossil fuel power. But even within the state, it's a contentious issue. You probably realize that FERC has the authority to cite interstate gas transmission lines, whereas that's not the case for electric transmission lines. You know, where states' rights would scream that this ought to be a states' rights opportunity. If you've ever been through one of these proceedings where the property owners come in and complain to you, I'd almost get that up because it's just no fun at all. In North Carolina, the Utilities Commission has to approve corridors for transmission lines above a certain voltage, but to the extent that the condemnor, the utility company, and the property owner can't agree, then the Superior Court, the General Court of Justice, has got to actually undertake the condemnation proceeding. And we had one of those at one point where the Utilities Commission approved a corridor for a line, but there's sort of an afterthought in the order said that this was a Progress Energy line. Progress Energy had to work with the property owners to try to determine exactly where that line would go. The Superior Court judge was faced with the condemnation action, and he tried to remand the case back to us to get us to give him more direction as to what we meant by that. And we said, sorry, buddy, you can't do that. You take it. And they ultimately settled the case. But it's a contentious issue.
Miles?
I think
I read a study in Israel that said that if you get sentenced by a judge right before lunch, you have like a 50% worse sentence than if you wait until after lunch. So hanger is real. And with that in mind, I want to note one of the things we're trying to figure out today is what are the jurisdictional gaps? What are the questions that we want? What are the tools that would help? I've got 3, but they are sort of informed by things that folks have said, and I'm going to let us talk for about 4 or 5 minutes over if folks will accept that, so that if there's anything that I'll at least make that option available. 1, are we clear on when public interest authorities align with project participant interests? Like, I'm not sure that we're clear on when the power to use these public interest authorities aligns well with when you're actually a project participant. So, for example, it's raised by this question of, does a project participant who wields eminent domain authority or permitting authority of some character, does that create a conflict of interest? And are we clear on when there are powers and abilities, permitting authorities, eminent domain authorities, when those should exclude you from being able to be a project participant? Have we articulated what national interest is as a transmission, permitting, and siting and project criteria? So, for example, putting aside whether it's right, whether it's true, the articulation that there is wind resource that we need to move out of the project area being the national interest that's driving the federal participation in that line. Unless there's an RPS or some other articulated reason why wind energy is a resource that is in the national interest to move, why is that a preferred resource? Why are we not saying that geothermal interests or some other, I'm not sure that we've articulated what a national interest is as a criteria for this. If there's a national RPS that I'm missing, I'd be happy to be pointed towards it. And then finally, what mechanisms can inform federal agency decision making in a way that de-insulates them from the yelling? That addresses Chairman Finley's idea that he would be happy to send some of the more vocal participants in that project to somebody else's doorstep. But I think more appropriately, like, what are some of the mechanisms that remove the moral hazard of decision making that's insulated from the impacts of those decisions? I don't know if we know all those things, but I'm just trying to articulate maybe an information need or a gap or something that we can do. I wonder if folks want to articulate what else y'all have heard from this conversation that if you knew what was going on better, it would help make better policy making. Keeping in mind that hanger is real and that you can send me by email your thoughts.
I have a quick one, which is in the history of this project, what was the driver for DOE to issue the RFP? And do you anticipate doing another one?
Well, that actually gets, that RFP predates my personal involvement. I think it was because there was at that time, and that would have been like, I guess, the summer of 2010, already kind of rumblings of interest in using the authority, and the department felt that it was necessary to come out with some public statement about how they would handle an application, what criteria they would use to evaluate it, and the like. Couldn't say now whether we would update that.
What was the Clean Line Group the only ones you heard from?
Clean Line is the only company that has applied under this authority, and your presentation mentioned some of their other projects, and they have not applied for those other projects. Just to be perfectly clear, and if they did, the first step would be to do NEPA, which takes like at least 3 years, So it's not like something that's just gonna. It would be a long time coming.
I have one question. the Arkansas Public Service Commission declared that Clean Line was not a utility. Was that the impetus for them then to jump to DOE?
Well, I think the Arkansas, in 2011, Arkansas PSC said that Clean Line did not meet the statutory definition, although there was actually, if you look at that decision, there was quite a bit of kind of favorable commentary on the project itself. It certainly was not a rejection of the project on the merits, but it said essentially that they didn't meet the definition of public utility because they didn't have any contracts enforced to serve customers in the state. Later, the Arkansas legislature enacted a statute that said you can't get a certificate from the Arkansas PSC if you're not currently a public utility and you haven't been directed to construct the project by an RTO. So I think that those two developments, created a need for federal involvement.
There's in some unnamed states, in the Northeast and that whole swath that didn't have on the map up there, there is trying to skirt some of the public involvement by trying to create transmission utilities so that they won't have to, they can bypass the public process. So this is an interesting one. This is very helpful.
Well, can I just add to that? But we certainly did not bypass the public process here. Yeah, I mean we had 15. I should have said, but like we had 15 public meetings. It received 700 comments. So we feel that we had a robust process.
That.
I know we want to keep talking, but we'll be eaten by the hungry cannibals if we go much further.
I'd just like to make a comment that this is Dennis Bergeron from the Maine Public Utilities Commission staff, that we've had a lot of transmission proceedings in my state lately, and I'm very familiar with the statute and our rules about what is required to grant a permit for transmission construction. And I know the language very, very well, and I know how we approve transmission projects that are associated with reliability needs, and states are kind of used to doing that. And we're faced with some projects that will likely be renewable projects, market-driven projects. And I think under our rules we could probably make an interpretation that the project is permittable, but I don't know how many other states actually look at their siting rules and can do anything other than reliability projects. And if states don't want to get jumped over, it might not be a bad idea for them to look at their siting authorities to figure out whether they can accommodate this kind of project.
Thank you. With that, please join me in thanking our panelists for this robust discussion. And now lunch is being served, correct?
Who's hungry?
Hi, everybody. We're going to be getting started in just a couple minutes if everyone can start to take their seats. Thank you.
Okay, everybody, I think we're ready to get started again. We've got some seats at the table that have been vacated by some other folks, so please come up to the table if you so desire. I think we've got folks on the phone as well. So our next topic, and our final topic of the day, has to do with reliability, resilience, and recovery. And obviously, there are many, many agencies that are working, some in alignment, some at cross purposes, on resiliency and reliability and recovery from natural disasters or cyber events, etc. And I think the purpose of this session is to talk about state and federal blurred lines of authority and responsibility and how some of the stovepipes that are out there can be better integrated so that we really do have a seamless national program for resiliency and recovery. I'm going to turn the mic over to Sharon Thomas from NARUC, who is going to introduce the two speakers for this session and tee up some of the issues. And I'd just like to put a plug in for sticking around for the final wrap-up after this session, because we're going to be talking about, have we identified throughout this two-day meeting, have we identified some of the issues that still need to be addressed across all 5 of these topical areas, and what can we do, what resources or tools are necessary that can help state decision makers the job they want to do on setting policy in a way that's effective for their stakeholders. So with that, I'll turn it over to Sharon.
Thanks, Jan. Okay, so in the past decade, the U.S. has experienced a series of devastating natural disasters, including Hurricanes Sandy, Katrina, and Rita, as well as the tornado outbreaks of 2011 and 2012, and increasingly destructive wildfires annually, just to name a few. The devastation that's been caused by these disasters has also been increasing substantially in recent years. Currently, the federal, state, and local governments all play critical roles in managing disaster relief. Local governments respond first, and then they turn to the state government if the disaster exceeds their resources, and state governments may in turn ask FEMA for help. In general, most disasters are handled by local and occasionally state governments. But in the last 60 years, and even more frequently in recent years, the federal government has become increasingly involved in supporting state, tribal, and local governments in responding to major disasters and emergencies. States are in charge of some things, and the federal government is in charge of other things. As we prepare for new kinds of response, we find that we're still working out the designation between state and federal roles. So here with us today is Wally Malia from Edison Electric Institute, who is going to talk to us about the private sector's role in emergency response events. And we also have with us Commissioner Liv Fleming from the South Carolina Public Service Commission, who will be responding to Wally's presentation. So with that, I'll turn things over to you, Wally.
Thank you, Sharon. Thank you for the opportunity to speak with you all today. As you know, Edison Electric Institute is the trade association for the investor-owned segment of the electricity sector. So all of you that are commissioners regulate our members, so I show you nothing but the highest deference and respect because I like my job. But I honestly am very pleased to be here to speak with you because we've, I think, as an industry, made a great deal of progress over the past 4 or 5 years in terms of how we respond to serious events. Natural disasters are probably the most likely, but we've been trying to build, as an industry, a response framework that is applicable across threats because unfortunately we never know what's going to happen, and we hope to prepare so that we can do, or our members can do what they really are set up to do, which is to serve their customers and to serve the public. So with that, briefly, EEI and our members, we serve about 70% of the ultimate electricity customers in the country. I would be remiss in not noting that our colleagues in the public power sector, APPA and NRECA, they also have emergency response frameworks. APPA works on a national level, kind of similar to the process that I'm going to describe. NRECA, they work largely through regional or state associations to provide that surge capacity in a disaster. And increasingly, through our associations, we're connecting with each other, both before and during events as needed, to ensure we understand what's happening and that we can try to respond as a whole industry. In our sector, among investor-owned utilities, emergency response and mutual assistance, where companies are able to call upon others to provide additional support should they have an incident that taxes their capabilities, has always been done on a regional basis. We have now 7 regional mutual assistance groups, which are comprised of utilities in a region that voluntarily support one another during major outages. There used to be 9 RMAGs after Hurricane Sandy or Superstorm Sandy in the Northeast. They consolidated to try to build better economies of scale. So there's 7 RMAGs that operate and support each other internally and then across RMAG lines should an incident be big enough. And this process has always been driven bottom up from members, from the actual operators, you know, the men and women that are out restoring the power, run these programs. They're the, you know, generally in our companies directed by, you know, a vice president of distribution or a vice president of emergency response and whatnot. And we've been quite proud of this tradition. It's worked for a long time, 40+ years probably. And for local and regional type events, this process continues. However, as was alluded, nature sometimes can throw everyone a a curveball, and so starting really in 2011, in that time period, we had Snowmageddon, 3 million people out for about 10 days. Then we had a derecho, which was a term I was not familiar with until June of 2012. And that was a real eye-opener. The thought that you could get basically a hurricane out of a thunderstorm means that it appears quickly and you don't have warning. The nice thing about hurricanes is you generally know they're coming. That knocked out, 4.7 million customers across the sort of Ohio Valley into the Mid-Atlantic. I cleverly went on vacation the first day of that, so that seemed like a good idea at the time, but I was not actually involved in sort of our emergency response stuff, so I was allowed to go. Then I think everybody knows what happens with Superstorm Sandy. Really an eye-opener in terms of the need to think about how do we consolidate response to respond on a national level. So from Superstorm Sandy, our board of directors asked EEI and to work with our members to develop a new framework to raise and elevate the mutual assistance process to a national level. So the idea here is that instead of responding regionally, resources are pooled and allocated on a national level. So for our members, we define an NRE as an event that is expected or has impacted, and it's important the expected thing because, in some circumstances you might trigger this before, say, landfall of a hurricane. But it impacts 2 or more regional mutual assistance groups, requires the response from more than 2, has an impact that's greater than those RMAGs can handle, or that creates a situation where there might be conflict or challenges to get the available resources. Because there are only a defined number of workers in the country, and so it's not necessarily going to expand the workforce, but it hopefully will allocate it more effectively. So when an NRE is activated, and I'll get to how that process works in a minute, all of those resources, linemen, equipment, engineers, vegetation management, basically all of the people you need to fix a distribution system are put into a national pool and are then allocated based on need. So it's driven, like our companies, from the top down with CEOs basically guide the process, are the ultimate governance entity, but we've created 2 new nationwide structures to really manage the process. The first, the National Response Executive Committee, is essentially the executive leadership. These are the VPs, senior VPs of distribution across our companies, and they serve as sort of the governing body to guide the process. And then underneath that is the National Mutual Assistance Team, the NMART, are the folks that actually do the work in terms of allocating those resources. And then those resources flow back down to the regional mutual assistance groups. Because one of the things when we built this structure over the past couple of years, we didn't want to lose the benefit of having regional and local control of the actual resources when they're out deployed. It's our view that companies on the ground are far better suited to figure out we should fix this line versus that line. We don't want to get into micromanagement, but we want to provide tools and resources to companies so that they can do that most effectively and efficiently. And the process also flows up because the information comes from the companies through the RMAGs to go into the NRE system. When I say information, the information on what workers are available and what workers are needed, be you an affected company or a responding company. We tried to build the process so that it was flexible. A CEO has to request this. This, in our opinion, is a big deal because it's changing the local, regional control of mutual assistance to a national level. So, there has to be a serious ask here. So a CEO asks for an NRE. A committee of our CEOs and the National Response Event Executive Committee meet to basically decide should we activate or not. We built in the process, a a potential timeout. For instance, for an incident that might not have actually impacted customers yet, like a hurricane, you may say, well, let's wait 6 hours, and we'll do this process again to evaluate, because there's a lot of uncertainty with things like hurricanes or other potential weather events. So we want to build in a way to trigger quickly if needed, but also a way to step back. Let's just make sure it's going to go where we think it is, because once you put the process into motion, you're moving an army of workers that has cost impact, that has logistical impact. It can be dangerous depending on the circumstances. So we wanted to make sure there was, a way to think about it, but still quickly come back to reestablish the process if there's a need. And then once the process is triggered, as I said, the resources, and these are largely people but also material, go into the NMART, who takes the needs and the resources and allocates them basically based on either expected impact if it's beforehand, or actual outages and trouble tickets. So we tried to build a system that's fair and is responsive to actual need. Actual outages basically trump everything in this formula. So the NMART takes the needs, the asks and the offers, allocates them, and then assigns those back down to the RMAGs. And then the RMAGs assign the actual crews back down to the individual utilities. So it gives that, it has the national allocation, but also still the local regional control of the people who know best to assign, these 100 linemen go to this company. And then the NMART informs the NREC and EEI of the process, and then we rinse and repeat. We build this process so that, the assumption is that this would be a multi-day incident. Sandy took, 8 to 12 days to sort of resolve everything. So that process would begin every day, and that's one way to potentially resolve, say pre-incident, there might be an assignment, and we wouldn't take resources away, but in the next allocation, then okay, the storm hit 100 miles further north, so you direct resources there. And as resources become free, as a company restores, they may release the resources that they acquired or be able to send their own crews elsewhere. That goes back in the system and repeats. So it's a dynamic allocation. It's not on day one, where the workers are assigned would be different than on day 5. This was previously done, paper and pencil and spreadsheets. We thought, well, we're in the 21st century now. They have these things called computers in the internet. So over the past year and a half, we've built what we call the Resource Allocation Management Program for utility personnel. And this is essentially an online networked tool that companies and RMAGs, the NMART and the NREC have access to make the logistical, the paper and pencil, the entering information much more easy and makes the allocation much more efficient. So we've asked our companies to input what they would be able to offer up, sort of their first offer, and that information in there on what types of crews, what their skill sets are built into this system. So should an incident happen, companies then can make requests through that. So it is much less cumbersome than building it in spreadsheets and then having to check it. And we think it's going to be a very useful tool. We also designed it so that it's scalable both up and down. Our first thought was we wanted this for a national event, NRE as we call it, but it also could be used by RMAGs, and we're strongly encouraging them to do that for a run-of-the-mill storm that you might need. Pepco needs 150 resources from somewhere else, so they could use the tool to make the request through that at either a RMAG or a local level. The other advantage by having company personnel be more familiar with it, should the big one hit, or maybe when the big one hits, the idea is that people will be more familiar with the tool. It'll be easier to use. So we're very proud, knock on wood, we haven't had an NRE yet, but this resource is, I think, a big step forward in making the process a lot more streamlined and a lot more efficient. Having tools and frameworks are no good unless you test them. While we don't want to see a hurricane or an earthquake, we have been exercising all of these. We're in the process right now of putting together a functional exercise in May that we will host. But we've tried to look at a number of different scenarios, and including in a number of different regions. Hurricanes are obviously most common on the East Coast, but last year through our exercise cycle, we looked at an earthquake that was followed on in the middle of the earthquake by a derecho on the East Coast. So how do you work the, say, reallocation of resources? This year we will be doing a functional exercise. I can't tell you because I'm in the cone of silence. I'm on the design team, but it will have a challenging component for our members that they will have to go through the process, use the tool, and this is the first year the tool's been active, so that will be our big focus for this exercise to test that resource. Now, finally, just to close up, at EEI we have I'll use your lines. So I don't want to say they're blurred lines, but we have lines where our focus tends to be more on the federal side or the national side. So this slide looks at how we try to interact with the federal government. And that's because we try to represent all of our companies, as would APPA and NRECA, who are also involved in this interaction through the Electricity Subsector Coordinating Council, which is essentially a group of CEOs from across the whole industry who convene to meet with federal partners in the case of a crisis. Now, our companies will be heavily involved, and actually already are heavily involved, with each state or local emergency management or emergency response organizations. We at EEI get a little bit involved in that, but we sort of cede that to our companies because they're on the ground and they're better suited to address their local needs. But as this process, as it flows up into a national level event, what we want to be able to do is make sure that both for mutual assistance, what I've been talking about here, but other challenges including cyber, transportation issues for, say, moving heavy equipment or personnel, access to spare equipment, all flow through on a unified approach of both effort and for message through the EISPC to the government partners. And it's a two-way street in that we primarily will give information to the government will give information for us, and then we have to both try to work to solve the challenges. At more of, particularly on the mutual assistance side, my level, well below a CEO, sort of on an operational level, we've been working really hard to try to build earlier and more effective communication with the DOE in particular, since they're our sector-specific agency, to deal with an emergency by plugging into the emergency calls they would have earlier in the day from an incident, so that operationally we're communicating, and then at an executive level we're communicating. And that's also a place where we're increasingly getting well aligned with the municipal and cooperative utilities, because if a big storm or an earthquake or other incident hits, they're not going to it's not going to matter how you're regulated or what your ownership structure is. People will be interested in getting the lights on. So we want to make sure that at the association level we're having good communication. So again, it can flow up on both sides and ultimately result in safer and more efficient and faster restoration. So that's my prepared remarks. I don't know, do we want to do questions now or do the response? But I'd be happy to take them now or later, Sharon, if however you want to do it.
Commissioner Fleming, do you have some remarks you'd like to make? Sure.
Well, as you know, South Carolina's had a lot of experience with natural weather events, with hurricanes, and now we're experiencing floods, which we had not been used to having in the past, ice storms, that type of thing. And in South Carolina, the Emergency Management Division, which is headed up by our counterpart, the Office of Regulatory Staff, is in charge of leading all management for these disasters, and the mission is to minimize loss of life and property and to restore things as quickly as possible. They work closely, and ORS is through this same system is in charge of all training, conferences, any educational session that goes on preparing for these disasters. They use the Department of Energy's federal ESF 12 role for information, and it acts as a coordination role, but the actual restoration of services on a regional scale are up to the utilities themselves. And they did not give me any information about the national level, but I know with Duke being one of the major utilities in the state and SCE&G, I'm sure that they're working very closely with EEI on that as well. But what I wasn't aware of, they made the point of saying that the Eastern Interconnection Planning Council that was formed as a result of the ARROW funding has, since it was established in 2010, has established relationships and provides an avenue for discussion between the various regional planning systems. So that's worked well in an area that I was not aware of had come out of that. From the state's ESF 12 perspective, we do not support other states directly with their disasters, but through the mutual assistance programs that you mentioned, they exchange crews and assistance to neighboring states. And I know from personal experience, they certainly work well across all the utility lines within the state. The co-ops, the IOUs, all work very closely together in the event of an outage. The Energy Office for the states also undertaken energy assurance planning efforts with the support of the Department of Energy's Infrastructure, Security, and Energy Restoration Division, ISER. And it included identifying specific steps and thresholds for escalating response. And in 2011, South Carolina participated with North Carolina and Georgia in what was called Red Earth to look at, to do an energy assurance exercise. And it was able, they felt like, effectively used our existing plans and authority to coordinate with both our federal ESF partners as well as our counterparts. The federal ESF 12 maintains a system called Eagle One, and it's a nationwide outage monitoring system. But they did say an area that they could use some help. The federal ESF system has refused to allow South Carolina access to this system, and they're saying, except during an event, it would be helpful if they could have access to that at all times. Also, since we did have a cyber incident where lots of securities were taken, lots of information about individuals in the state were taken. They've really worked hard on cybersecurity, and I know our office also, that has been a big issue. And they work with the South Carolina Department of Technology, to develop information security policies and procedures. And there's a common framework that's used throughout the state for all of the agencies so that they feel like it gives more support to doing that. And I know that our utilities have worked very actively with this particular process as well as their own systems that they have in place. And one of the things that I wanted to mention, it seems like with every disaster that we have, lessons are learned and best practices are put into place. And during the polar vortex, just one instance that we had, the valves for the generators were not sufficient for the extreme cold that we had. So the system went out. And because that was happening to so many systems in the area, there was no extra supply for them to purchase for that. So they had to go to rolling blackouts. So with the climate change, with having more extreme weather, it's really making them rethink how the systems are in place. So they've had to replace those valves that will withstand much colder temperatures. It seems like the biggest challenge we have, well, of course we have the hurricanes, and we learned from, I think it was Floyd, about the traffic jams long before Georgia had their experience and with your hurricane on the interstates and some of the other places. We had that traffic jam, and so they have really worked hard to put in an evacuation system that allows transportation to move effectively. And I think it's worked pretty well in previous events. But the ice storms are the ones that seem to be the most damaging for us. We don't get as much snow as we do ice, and that always means the trees come down, lights go out, and restoring that can be quite a challenge, especially in the lower part of the state where the geography of the swamplands come into play. So there's some pretty exciting pictures of workers in the swamps trying to replace the poles there. And the challenges move, it seems like the smaller the utility or the co-op or the more rural the area, those areas always are the biggest challenge to get electricity restored. It just takes a longer period of time. So those are the challenges. We work closely with all of the agencies that are out there. Certainly had that opportunity once again with the flood in Columbia on down to the lower part of the state. And I'm sure there are plenty of lessons to be learned from that as well. But we just appreciate how well we work together within state, but within our region and with our national entities. Though I'd just like to know when we're talking about reliability, in South Carolina, I was thinking more of national disasters, but that was part of this as well. That hasn't seemed, I think in vertically integrated states, and we certainly have a large amount of nuclear, of actual generation, we produce rate about 50% of our electricity from nuclear. So our reliability in that regard is good. But I'd just like to know, among the group here, as we're entering into our phase with Act 236 with distributed energy, with renewables, we don't think there's going to be a reliability problem. But, you know, especially with the smaller units, there could be. But I'd just like to know what is out there, what we need to know that we don't know at this stage of the game? And also, is there a difference between vertically integrated states and states where they buy from the market, market access? Does that make a difference in the reliability issues and how those are handled?
Wally, do you have any?
Sure. I just 2 points, I think. One, I would be remiss if I don't mention cybersecurity. Certainly a hot topic of the day. We are through the EISPC, so this includes basically all pieces of the electricity subsector, are looking at how do we develop what we call cyber mutual assistance. And the concept is similar to traditional mutual assistance. The implementation is likely to be different because it's perhaps different skill sets, and if you take a lineman from South Carolina and go to Delaware, they probably can do the same type of job, assuming they're rated and after a safety check. In cyber, some of the skill sets may not be as easily transferable. You may not have to move people. Maybe you can do things remotely. But the idea of how do we build, again, a similar type of surge capacity to address severe cyber incidents is an extremely high priority for our CEOs, and we're in the process of trying to build that out right now by working with our members to develop a framework and then also look at what resources would be needed and what would the scope be to build that. Cyber is perhaps more interconnected than even, say, electricity, so the dependencies, particularly with telecommunications, are highly critical. We're also looking at interdependencies with, say, the financial sector as both an important provider to the utilities and vice versa for us to them, but also a huge target. So cross-sector activities on this are really important. We're trying to build that out. So that's, we don't have it as well developed at this point. We certainly will soon over the next year or so. And so that's something that we take very seriously and are working hard to address. One area of potential cross-state activity that came to my mind as the Commissioner was speaking is ways that governors might be able to potentially support each other through things like the National Guard. They can play an important role in road clearance, security, support. They often have resources that are very useful to restoration, and that might be a line, assuming they're not federalized, which I think would be pretty unlikely in most circumstances. And it's my understanding that there are ways that states can deploy to other states, but that might be an area that would be worth exploring a little more from the utility perspective, so how those resources might help to affect a faster restoration.
Oh, so my question is for Wally and for the folks around the room as well. Do you all feel that the subject of cybersecurity, which is, planning for such is I believe at this point mostly a state responsibility, and states require their utilities to have cyber plans in place. Do you all feel like it's been mostly a state responsibility but needs to be more of a state-federal responsibility, or is this mostly a federal responsibility with input from the states? So that's my question for everyone.
John Farbilla, Commission staff. We recently had a presentation from PHI concerning cybersecurity, and they specifically advised us that they did not have the capability to protect their facilities from a state action for cybersecurity. They just don't have those types of resources, and they specifically stated they're relying on the federal government in order to support those types of threats.
Yeah, Tom Sloan in Kansas, and a number of states have intelligence fusion centers. Kansas is one of those. What has set us apart is that we have our state's largest IOU sitting in the fusion center next to the state highway patrol and you know, National Guard and whatnot, and they're all connected to DHS and alphabet agencies in DC. So we've tried to incorporate the primary public and private sector cybersecurity people into a seamless partnership, both at the state level and then with the feds. So it's one of those things where actually we've had FERC commissioners and FCC commissioners and their IT security folks come out to see if that partnership, if you will, can be strengthened. We also had Assistant Secretary of the DOE out all in the last 3 weeks.
So I just wanted to respond on behalf of my ICER counterparts to the comment about access to Eagle Eye information. And in hearing that comment, I actually texted Jeff, who had to scoot out for a meeting, unfortunately, and he replied back that they do recognize that that's a current limitation of the Eagle Eye application, but they are working to expand access to that to all states so that it doesn't have that limitation. Apparently, there's these pesky things called contracts that are currently limiting who gets access to it, so they're working on that solution. So I just wanted to share that with this group.
Thank you. Chairman Finley's part is up.
Yeah, Ed Finley, North Carolina. I want to respond to Commissioner Fleming's question about reliability in adverse winter storm events and that type of thing in the restructured markets. And you might recall yesterday when we were talking about that the EPSA decision was not the latest chapter in demand response in PJM market, and I couldn't talk much about that because my FERC counterparts were down there and they're still considering all these things, but now they're gone and I can talk about it a little bit more. PJM is moving towards a capacity performance way of compensating DR and other generators when there's an adverse winter event. In other words, if you are in the current regime, you all help me get this right, that you're you experts on PJM, but if you are a demand response provider and what you do is curtail your air conditioning in the summertime and get paid a lot for it, that's not going to help you any in the wintertime when you have a cold event in the mornings, you know. And so what PJM is going to do through this capacity performance regime for the 2021 delivery year, as I understand it, they're going to change the compensation level. And you've got to sort of have your resource available all year round, in the wintertime and in the summertime, in order to get paid the full amount that you want to get paid. And at the latest OPSI meeting, Organizational PJM States meeting, we have the Interconnection representative there, the curtailment service provider, and the representative of the industrial customers who make their facilities available for curtailments, and they were really complaining about that. You know, they won the EPSA case, but they're really complaining about the regime that PJM is going to compensate those people in order to make sure that the capacity is there when it's needed in emergency events in the wintertime, for example. And I think one of the reasons that PJM is moving in that direction is the experience it had in the polar vortex, when it, of course, it couldn't call on the demand response that curtails or interrupts in the summertime if it's air conditioning load. But even the generators weren't able to perform as they should have. They weren't able to perform when they were called upon in accordance with the contracts and understanding that they had with PJM. So PJM is going to this regime. I think they've sort of picked it up from what ISO New England does, and you're gonna get paid a lot more if you perform when you're called upon in emergency situations, but you're going to get really penalized a lot more if you don't perform when you're called upon when you're supposed to in the emergency situations, in order to address the situation that the market response type regime in the restructured market. That's a shortcoming that they have experienced more so than the vertically integrated systems like we have in North and South Carolina. Correct me if I'm wrong, you PJM experts, if I misstated that.
Yeah, just a response to Commissioner Fleming's question about the difference to disaster response and vertically integrated versus market areas. I don't think that there's much difference. I mean, these are most of these disasters we're talking about are occurrences. These storm events have their greatest impacts on the transmission system, and the transmission system, those are still regulated utilities, and they scramble. You know, there's assistance that's provided across the states, regardless of the storm, whether it be a hurricane or an ice storm. They scramble. We get crews coming in from Canada, so it's a mutual assistance program that works very well.
Same issue, and then bring up a couple other things. To agree that most of the impact from storms is primarily on the distribution system, as well as on the transmission system. And of course, the distribution systems are all still regulated by state commissions. I think there are some differences. For example, Commissioner Fleming mentioned, you know, the valves that were needed on the power plants, on the generating system. Well, in a restructured state, you don't have any control over the power plants. It's all merchant generation. And so if that had arisen, you know, when that happened, a commission in a restructured state wouldn't be able to really do anything about it directly, except so you have a limited amount of authority there. Two questions that I had when we're talking about, again, to get back to physical damage and physical responses, and to talk about backup generation and demand response. Because backup generation can be a resource in a disaster situation, getting them back up. Again, and I've been talking to folks from Maryland. When we talk about information gaps that we have, I don't know how many state commissions have information or access to information on who has backup generation, you know, who regulates it, who is doing demand response in terms of, at least in a restructured market, it's people like Interrock and the aggregators and all. Interrock, I'm sorry, they know what their contracts are. We can't get that information from PJM. So we get information, well, we had a disaster and there were 9 megawatts of demand response that were called on. We have no idea who they are, where they are, et cetera. And I don't know if other states have that issue or have found a way to know where is backup generation, who's got what, you know, who has that ability to respond either to island or to keep going in a power outage situation, and who doesn't. And then the other question I had, there's another agency, another backyard that we're playing with, or people are playing in when we have these outages or storms, and that's our emergency management agency. And they're the ones who deal directly with FEMA, for example. We just had a briefing at our agency. There was a relatively new director of the city's Homeland Security and Management, Emergency Management Agency, EISPC. It came over, and one of the things that he mentioned was that after the, was it after the Derecho or after the last big snowstorm that we had? Yeah, where it was, you know, it was declared an emergency. They got the federal money from FEMA. 25% of that can go for mitigation. So I thought nobody ever told us that the commission, that the city was getting, 25% extra. Nobody ever asked us what some good mitigation might be, like hard things to poles, et cetera. So I think and I suspect that may be true in other states too. There's another whole sort of silo, if you will, there of a federal agency and a state agency that are making decisions about what they're going to have in place in anticipation of the next problem, next hurricane or tornado or flood or whatever. And yet it doesn't seem to be connected or coordinated with any particular needs. We're ordering the company to do certain things in a disaster. So they just put a pin in that as an information gap and another backyard or another set of backyards where lines are blurred. Forget the wall was next to it.
Yeah, a quick question for Wally and then a response to Commissioner Fleming's question. So day-to-day electric utilities, their field crews are out doing stuff, hooking up new customers, new subdivisions, what have you. So to take them off that work and send them somewhere else to do storm restoration has a kind of a cost. There are customers back home who aren't getting hooked up as quickly as they otherwise would. So my question is there a threshold of an amount of outages or length of anticipated outages before it's kind of fair game to ask for help? Because you are inconveniencing the other utilities in a sense.
Right. There's not a sort of minimum. I think it depends on what a company feels they need. In a national level event, if another Hurricane Sandy or Superstorm Sandy comes along, that's pretty obvious. It's sort of up to each individual company to determine that if we have, if you have 100,000 customers out in Delaware, that's a lot of customers. You have 100,000 customers out in California, it's not so much. So the absolute customer number, may not be really the threshold. I think it's the expectation that each company has that they can, restore as efficiently and as fast as possible, with the possibility of extenuating circumstances. One thing that, companies, they have to pay for this, obviously. So if, crews come from Georgia to Delaware, PHI is paying Georgia Power or whomever sent them. So companies are made whole. So there's, so the cost impact is, balanced out. But that also, means companies want to make smart decisions. I think it's fair to say there's one thing that will get a CEO fired, though. It's incessant, not being able to get the lights back on in an appropriate time, and nobody knows exactly what that is until you go through it. But I think that companies are very aware of that, particularly because over the past 4 or 5 years, the level of challenges to restoring after increasingly bigger events has just sort of raised the bar. So there's no threshold, but I think every company is very cognizant of the need to get power back on. That being said, companies will often first deploy contractors that may be on their property so that some of their crews can stay on. But that's potentially a blurred line because sometimes companies have requirements to get a project done, and if they're willing to try to support other companies, how would that be balanced out for meeting, say, a performance standard for building something that those things get pressed. Fortunately, companies are very willing to support one another. I think it's there, but by the grace of God, they all feel. But that's pretty unique in this industry. The structure helps, but we've had conversations, for instance, with railroads and telecom and banks and the oil companies, and they don't do this. They can't because of antitrust laws. So.
Thanks, Jan. A quick question about just sort of following on Commissioner Fleming's comment that with the frequency and scope of these events likely to increase. Are you starting to think about what the impact might be on the workforce and how that's, whether it's training or numbers or contractors, what is the longer term trajectory of what you're going to be needing in years to come?
That's an excellent question. The industry is very worried about, I would say worried might be an appropriate way to describe it. The workforce is aging. You can't just take someone off the street and put them on a high voltage line. So we've created a program at EEI called the Center for Energy Workforce Development to take a sort of a longer term approach to try to help bring in employees or potential employees from the military, to help build STEM. That's all a longer term project, but I think companies are very aware of that the challenge to meet increasing expectations of customers is raising the need to look to how do you expand the workforce appropriately. I don't have all the answers to that, but I know that I saw a CEO survey, I think it was done last year by a consulting firm, and workforce was, I think, the second or third most important issue facing them. So it's certainly, I think, a very high priority for many companies.
Can I just ask one other quick question? As a Baltimorean who lived through the derecho and didn't know what it was either until we all got knocked offline, in the investigation that ensued about the utilities' response to that, one of the big issues I recall was that there wasn't adequate communication with customers. I mean, you've laid a very impressive infrastructure of everything down from the utility all the way up to the national level and back and forth, but sometimes the customer gets left out of that loop. And I remember sitting with people that had been told multiple times, it'll be tomorrow, no, it'll be 2 days, no, it'll be tomorrow, and just it kept until it went out 3 weeks before they actually got restored. But the information was wrong. It was setting the wrong expectations. People didn't have information. Are you looking at that issue and that set of problems?
We are from sort of one step removed. I mean, we don't get directly involved with communicating for companies to their customers. That's not a blurred line for us. That's a clear line. Really? Companies have to address that. But I will say this, I used to be in our communications department and I used to do a lot of customer research. And the challenge of getting customers to understand, the burden is huge on companies to do that. And every time, you have a storm or you have an incident, you have to reinforce, what are expectations. The bottom line question, people want to know when is their power going to be restored. I think that hopefully some of the investments in smart meters and smarter grid and better predictive capabilities from on the technical side hopefully will make some of that better so that the information companies have on their systems is more robust, which means they understand what's happening so they can communicate more effectively. On a macro level, we've looked at how do we communicate as an industry on this, and that's a critical component, particularly on the last slide I had there. Well, I don't know if it's up anymore, but in terms of having unity of message between the industry and government, and that means we have to share information effectively so we both understand what's happening and can address and meet expectations. But I think if you had any company person in here that was in their communications department or in their emergency management department, they would say that is one of their greatest challenges because it's never in the company's benefit to give out bad information. I mean, they don't want to do that. Sometimes it's very hard to know what's right if you're in a fluid situation, but that's a huge challenge that hopefully some of the technology will improve, as well as changes in communications. Now everybody in the world can know what's going on in my neighborhood because I can communicate through social media and the internet much faster than even 3-4 years ago.
I think we're coming to a close on this session. I see 2 cards up though. The session to a close.
Wally, this is Morris Schrein with Maryland. I want to thank you for your description of the mutual assistance program. I'm thinking a little bit about.
Sorry, could you move closer?
Sure. Thank you for the description about your mutual assistance program and showing how it works. You know, thinking about the blurred lines, I just wanted to make an observation. I think when we get to a situation where there is this a big need for mutual assistance across several different regions, the disasters have been declared. It's probably a presidential declaration. I think the blurred line probably may occur when you get to something a little bit smaller, when you're trying to get resources from one state to another, where one governor has declared a state of emergency, one hasn't. No one really knows the rules on how to transport this mutual assistance, and that's probably something that's pretty key that needs to be worked out.
Thank you. Final thoughts, Chairman Kane.
Wasn't just so much a thought as an announcement, a reaction to, again, Commissioner Fleming saying coping with all this climate change and these odd events happening. It's snowing in Maine, southern Maine, right now. Yes, it's April 26th, and it is snowing furiously.
No, we're all going to talk about simultaneity. So simultaneity is a word that my phone doesn't autocorrect to be anything else. So that's how I know it's a word. It's actually a word that I stole from Scott Hempling, about whom I'm not making any comments. He's a really smart dude. Yesterday, so let me start by saying, like an RTO or the state of Minnesota, I have a plan. My plan is that what we do with this last session is not the death march to 3 o'clock, but rather that we would run through at a high level some of the Santa's list that has come up through conversation today with technical assistance requests and unknowns, and what some of the things that we would ask for to help us with the blurry space. I'm going to go section by section through each of these 5 areas that our work groups fed us. My list from each of these is pretty short. So far, an hour, get out of here a little bit early. Everybody okay with that? It seems like a nice day outside, and maybe we can catch some of that. And to help me with that, what you can do is I'll throw out the ideas that I had, and if you, this is sort of the last call, if you can throw out your senses of what would help, what do you want to ask Santa for that would be convening, technical assistance, research, whatever it is. It helps us move from a place of not knowing to a place of knowing. Before I start, we can come back to this word simultaneity. Our first session yesterday, where we started exploring the sort of the ambiguity of federal and state jurisdiction, that boundary, what we talked about at length was this change in the Supreme Court, that the viewpoint from the highest legal authority has moved from holding up as the paramount goal a bright and shining line to simultaneity, that authorities can overlap, that activities can exist in one another's yards as long as the primary intent
is to regulate the things that you're supposed to be regulating, and that if in doing your job it has an effect outside that area, that's okay. What that means is that rather than today us discussing how do we reestablish a bright line, it's how do we deal with the reality that the courts and technologies and markets and the general trend of things has moved us into a world of simultaneity. Like, we may not need to fight over jurisdiction, but it's better to understand the areas in which those jurisdictional questions overlap. So that's my editorial kind of piece of steering. So if it's okay, what I'd like to suggest is that from my ridiculously scribbly notes, that I throw out a few areas that might be on Santa's list for each of these, and then ask you guys if you've got additional things that you would say, if I was asking Santa, I would get this. All right? So we'll start with the work that was raised by our evolving electricity sector work. We heard from FERC and from Aiken Gump, and I think that at the high level, what I heard was that there may be old collaborative tools that we may want to bring back up. Chair Finley raised the idea that there may be lines we don't want to discover, that there may be solutions that we can solve in a collaborative way so that we don't have to face them in court, so that reinvigoration of the collaborative approach, maybe the FERC church kind of collaborative approach or maybe something else, would be useful. A second ask Kim Jones raised that there are lots of questions in the mail in this area that relate not to demand response but to storage, microgrids, and distributed energy resources. Those were the two high-level ones. There was also one that I was a little careful about that asked, would there be an interest in someone developing some samples or some ideas around demand response pricing that doesn't treat demand response specifically as capacity? Other ideas that y'all were carrying around from yesterday? I see Kate Marks' light on.
Well, yeah, I just wanted to note that Kate Marks from DOE, EPSA, Energy Policy and Systems Analysis. We hear a lot about coordination, and I think it's come up several times, but I think what we're struggling with at the federal government is, you know, of course we focus on our convening power as one of our main priorities and ways to bring people together. But I think what we want to get to is when and how and what we really mean by that. So any input that you all can provide to that end about what the expectations would be, what the outcomes would be, what the timeline for that type of collaboration would be in certain areas, I think would be really helpful, as opposed to simply putting up a recommendation that says more coordination.
Other feedback about Santa's list for the evolving evolving electric sector work group area. Kim Jones.
I just want to echo, and I appreciate your remembering the energy storage, microgrid, the distributed energy. There are pockets of states that are working on storage. It's on the laundry list for North Carolina. But California and I think Hawaii are ahead of us. And I think the time is right. It's kind of not too late, I guess, in terms of getting it right. And I don't think this is an issue where anyone's really got it totally figured out. And going after it, I think, could bear some fruit, as opposed to some of the looking backwards issues that are harder.
Awesome. Dave Johnson also raised that he's interested in understanding if there are pricing policies that have followed the era-driven investments in technology. So in other words, did spending Recovery Act money on infrastructure have any affiliation with whether pricing policy followed with that. Might be an interesting piece of research. And it's probably already done. It's probably just synthesizing existing stuff. Okay, last call for evolving electricity. This morning we had our...
Oh, Miles, sorry, I had one more that I wanted to add to the list that I heard. There was a mention of if Congress could help give FERC guidance to avoid SCOTUS or, you know, avoid court decisions. I think it went a little bit beyond collaboration, so I just wanted to hone in on that point a little bit. I don't know if it was Chairman Finley that made that comment.
Okay. On this morning's conversation on the CPP, we had a number of pieces of input. One was this idea of a APCA-style roadmap, that diagram that some people would have said looks like the old train wreck thing, but for multiple sectors and multiple policymaker sectors. A second was collaborative tools for bridging agencies as they're either doing planning or as they're just dealing with energy air regulatory frameworks. And I don't know what that collaborative tool would be, but we've done in the past stuff like wedding planners guides for how to get air agencies and PSCs to get married. Exploration of the link between depreciation of plants and carbon pricing, and research into whether there are linked patterns there. Exploration of trading scenarios so we can figure out market policy interactions and unintended consequences. Implications of solutions-driven emissions leakage, solutions being things like EVs and backup generators in DR, in demand response and storage. Information about how grid modernization can inform, predict, and help measure costs, as well as help decision makers figure out who pays. And then finally, more information about program links to methane programs and to non-electricity sectors like manufacturing, so that we don't have a fight between manufacturing and electric power sectors when they get regulated over who gets credit for things like conservation. Other unknowns on the CPP or air energy thing that you guys heard that you wanted to throw out? Come on, guys, this is very boring. I'm doing all the talking. I could do that. Maybe if we could have Glenn and Christy like provide some backup song or beatboxing. Excellent. A good Prince, our first Prince reference of the meeting. I can't believe it took us 2 days.
Miles, I thought you did do something with Prince, though.
Did I do something with Prince?
Yeah, you did. I think you did. I can't remember now.
Oh, dear.
But anyway, I thought Darren mentioned something about depreciation and carbon pricing.
Yeah. Mm-hmm.
Didn't you?
Excellent. Yeah. That's on my list, Sheree. That's
oh,
awesome.
okay. I
Yep.
didn't hear you say that.
No, I'm with you.
Okay.
No?
Does work. I heard something about the Clean Air Act. Maybe this was Commissioner Kane. The Clean Air Act could use some modernization as demonstrated by some of the issues referenced in the ozone battle and some other areas.
We'll note it. I'll figure out
what we mean by that.
Yeah, I'll figure out a Kane-approved, elegant way of articulating that. That doesn't, well, you don't even have a member of Congress, so what are you worried about? Okay, I'm moving on to my handwritten notes, which are really great. For the clean session, oh, the coal leasing session, did I? Let me come back to that in just a sec because I don't have it in front of me. Here it is. An understanding of the strategic pathways that link to different kinds of energy resources. For example, mapping for an energy resource. If there are conflicting policy pressures for who sells it, who can lease the land it comes from, who constrains it, who can develop it, some sort of federal policy pathway and commodity pathway analysis might be of interest. Maybe a map. Information about job impact, skills, and retraining and how those link to federal energy resource policy. Understanding of the leasing pathway and the policy pathway as it relates to coal in order to understand marketplace implications for gas and other fuels. Relating federal policy that affects coal to the targeting of economic development in places like Appalachia. Anything else from that coal session? Ed, you're looking at me meaningfully. You're shaking your head at me meaningfully. Okay. This is great. If I do all the talking, we can be done in about 3 minutes. I'm going to do it cattle auctioneer style. Then finally on mutual assistance. Clean line? Damn it. Okay. Are we clear on when public interest authorities align with project participant interests? So if a Fed agency is both in possession of public interest authorities, like things like eminent domain or permitting authority, and they're also a project participant, are we clear on how those two things are allowed to interact? Have we articulated national interest as a participation criteria? Like, what is national interest and what defines and characterizes national interest that then opens the door to federal agency participation? Dennis Bergeron.
There we go. We have FERC Order 1000 that talks about public policy projects that have not really been defined anywhere, maybe Clean Line is an example of a public policy project, but they didn't use that phrase. So putting a little more definition around that would probably be helpful. Okay. And the related thing is that that's policy that's out there. And the comment I made earlier about whether our state statutes and siting authorities have kept up with that, and what have we got back at home in the bag of tricks, just so that maybe we can steal the march. We don't get preempted by the feds because we have anticipated it and we have some way of regulatorily handling it.
Just to jump in, what happens when the public policies are in conflict, where Iowa doesn't agree with Missouri, doesn't agree with Kansas? You know, how do you sort that out?
I've also got a number of other things that are so specific to Clean Line that I'm almost worried about even articulating them. But for example, understanding the threshold or the trigger for involvement in a project under 1222, since there's only one 1222 project that's been moved forward, and it was the first people that ask. Is it just anybody who asks gets access to 1222 involvement from a federal agency? Like, it doesn't look like there is a criteria for, we weighed your ask, it met these criteria, and therefore let's go. There was just interest in exercising the authority under 1222 and when the first gang of folks showed up. So I probably said something very uncharitable to the Department of Energy there, but
actually there are criteria in the law, but the standard was pretty low.
Okay, well, I'll delete that one, and please also delete that from your memories, jurors, that I raised that. And then lastly, I've got mechanisms to facilitate states reviewing their own siting rules and articulating patterns about what siting authorities you have that enable you to permit different kinds of things. Maybe they're reliability projects or maybe they're intermittent kinds of projects. This is the thing that Dennis Bergeron brought up about the wind projects in Maine. Other clean line unknowns that help us understand gray lines a little better.
I came up with in clean line, but when I was thinking about siting, and we were talking about, again, people's backyards, and someone mentioned flood control. There's another whole set of federal agencies that deal with dams, with hydroelectric, that deal with floodplain issues, as well as then state policy and state agencies. And those, I'm thinking, I think I was reading that Vermont was looking at, Governor maybe was looking at buying some of those dams on the Connecticut River to create hydro. And then we've got the state of Maine that wants to open up the dams so that the fish can get through and the fish can come through. And then you've got federal agencies that, you know, they control those waterways. The New Jersey folks have left, but we had that whole issue of, you know, the line that had to cross the Delaware Water Gap. So there's a whole lot of other players in there that affect a siting decision that may be a state siting decision, or it may be a interstate siting decision, that policies aren't coordinated.
Let me ask this question because I'm really curious about this. In your states, when you have new folks or when you have folks who are experts in other domains who are coming into the realm of siting, do you know what institutional kinds of like training is available to teach people? I know about rate schools. I know about programs where you can learn planning, but siting feels to me like there isn't a lot of institutional capacity. Darren, you're second. First Kane, then Darren. What do we do when we need to learn about siting? And is what we know about siting changing per Dennis Bergeron's, you know, we know how to cite something if it meets ability criteria, but there are new kinds of criteria that are changing what we understand by permittable.
I'm not aware of anything for commissioners or for states. I have seen courses that, you know, you get every email for every webinar that exists in the world, of seems to be more aimed at training or helping transmission providers or transmission developers on sort of what's the best way to get a site, you know, approved. What are best practices, what are lessons learned in sort of how to deal with the public and how to go through that. But that seems to be more from the developer's point of view, although it might be interesting for a commissioner to go to those courses, or who's ever in charge of siting, to see, you know, what people are who are trying to get something approved, what they're being told, how to do it. Anything aimed at the public officials who are making those decisions.
As a South Dakota staff analyst that gets assigned to the siting dockets, each state probably has a very specific siting criteria that the analyst would need to review to make sure the company properly addressed in the application, and then it would be the commissioner's role to decide if that application met the applicant's burdens of proof that the facility will not cause certain criteria, whether it's environmental harm or socioeconomic injury or stuff like that. So I don't see how specific training would aid in educating a newer analyst or commissioner or whatever on the siting process, because they're all specific by state and they're all depending upon the state's policies and what they want to pursue as far as investment in energy infrastructure and so forth. You know, counter to that is like rate design, rate making, class cost of service studies. Those are all kind of standardized and very specific and accounting specific, and so there is a lot of cross-training amongst the states that organizations have capitalized on in order to train folks on.
I think instead of saying yes or no, what you just said was, here's a challenge, Miles. It's a good answer, though. You know what that's going to be for me.
I think, Mouse, to your question was sort of not just how do you deal with what your laws are or your policies are, but are there things that you're missing, or are there new things that have changed that you might want to consider? We have in the district, we're having our workshop on Thursday because we have a state law that says nobody can build a facility for the retail or wholesale of a generating facility for the retail or wholesale sale of electricity without the approval of the commission. And that's all it says in the law. And our rules that we have, which are how do you get a power plant approved, have nothing to do with something like combined heat and power or anything else that's kind of a modern way to generate electricity, as well as even just defining what's wholesale or retail sale. So there's a whole lot of gaps there may be as technology changes, as distributed generation changes, as not just the accounting rules for siting, but the accounting rules for, it's not just an accounting issue. It's a policy issue, a social policy, a public policy, an energy policy issue. And there may be things that states could learn or get some ideas about how to, shall we say, modernize that.
Lots of cards raised. Commissioner Finley.
As far as training, there are engineering firms that specialize in siting, and what they do in our state at least, and I think this is pretty universally followed, they look at all the requirements in a particular state, the utility commission's requirements, the graveyard requirements, the environmental requirements, the wetland requirements, the Indian mound requirements. They assimilate all that information, and they go and pick out 3 particular routes, A, B, C, and then among A, B, and C, they work with who's going to build a transmission line, and they pick the best one. Then they announce that, and everybody affected by the route that they picked says that's the worst thing they could possibly do. But they come in and recommend that, and the Utilities Commission, if it's smart, will pick that route, because if it doesn't pick that route, it's going to pick another route, and then it makes everybody else mad that thought they were off the hook. The point being that there is a lot of training, but it's sort of specialized training, and it's done by people who do this regularly on a systematic basis.
Marcus.
Yeah, I just want to make the comment that I think that siting is changing with the emergence of like energy storage and DC lines, where now there might be more parties involved, and I'm thinking specifically at like the ISO level, where what could either be broken out cleanly into a transmission or a generation project can now be on the fence, where you have to go into an interconnection queue, and there's more things to consider, and then there's more different types of studies that have to be done that are outside of what would primarily have been state control in the past. So I think that's something that is emerging as an issue, and I believe FERC has a technical conference on that coming up to look at some things like that, and how that plays out will be really big.
Thanks. Catherine. Succinctly said. Jennifer.
One issue we didn't get a chance to explore on this panel was the public process of taking comment, and they pointed out that they had started the NEPA process, did NEPA comments, and then later decided that they needed to have an expanded comment process for the actual rule itself. And if you read some of the history of it, you see that this was something that was later added when they realized the requirements of the statute. And I think kind of going to, I think what Chairman Finley was saying, I think it was you, about the siting process at the local level, and make sure you get comment there. There's making sure that you're having the right people comment at the right level at the right time. And if you have too many processes, is that somehow getting lost? And are you targeting the right people for the specific they want to talk about in their comments?
So just to kind of build on the comments so far, I'm like Derek, I'm one of the analysts who actually look at the filings when they come in. And I always look to see, typically the utility will have had an open house with the people who might live along the route. And if they do their job right, part of the outcome of that open house should be that they get comments that tell them what the community's priorities are. And so they might be things like avoiding trees, or avoiding taking farmland out of commission, or avoiding parks, or in fact targeting federal land as the right place to put it. Those priorities of the community, if they do it right, they get priorities from the community, and then they translate those into the scoring system they use for the routes. And it actually makes the whole process maybe not pleasant, but at least it brings some logic to a really emotional issue.
Do I see any other cards up?
One right here.
Darren.
I just had one more comment, not necessarily specific to the training question, but I guess in terms of when a federal backstop is needed to be taken, I mean, the question that I would have is, you know, are there legitimate areas of need or benefit cost disagreement? What should be resolved, you know, by the states before triggering a federal step into the project? And if so, what avenues are there to discuss those issues, and are they thoroughly discussed before, you know, the federal backstop is taken?
Great ideas. All right, now I'm going to move on to cyber. So you're going to skip that whole thing. Sorry, Carrie. Okay, on the emergency response, Delaware raised the question of kind of scaling and attacker capability versus defender capability, which I thought you raised it. You said PHI. Ah, John is now, he's cleverly disavowing any involvement in anything that has anything to do with the discussion of cyber. You were never liable, brother. Tom Sloan brought up a bunch of interesting information sharing pieces that I think remain for other states' questions. The Kansas has doubled down in a big investment, and I'm not sure exactly what the technical assistance ask is that's related to that, but it has to do with something to do with information sharing and how big an investment should individual states be making versus feds be making in those information sharing structures, because the Kansas Fusion Center is the best in class, and I'm not sure all the other states are going to do that. But I'll figure out an elegant Tom Sloan approved way of articulating that. The Chair Kane raised the disproportionate response requirements for both physical and cyber attacks on distribution systems, because that's where most of the stuff goes down. Ed McNamara and others raised the questions about better information sharing about where backup generation is, who's capable of responding to demand response, who has a microgrid, who can island. All of those issues are invisible to the Public Service Commission. And then I forget who raised the emergency management agencies get mitigation money, and there are other emergency management agency related institutional silos that don't relate well to public service commissions and other state decision makers. Added to that from my own list is there's a whole mess of things that have to do with the activation of the National Guard, and there is a whole mess of questions that have to do with a capabilities assessment and description relating to cyber mutual assistance. To me, it feels like big national level events, there are only 3 or 4 ways that those things can come at you. They're either big physical events like hurricanes or seismic events or tsunamis or something that have a big infrastructure destruction component, or they're GMD EMP, which either is the sun or some foreign country, which definitely will invoke a bigger than one state response, or they're cyber. And I think for a bunch of these things, we haven't figured out the capabilities that are required to respond to that. So we haven't built the teams, so we haven't said this part of the team comes from the feds and this part comes from not the feds. So I think that there's a whole world of kind of capability assessment and articulation remains out there, and the cyber piece of it is probably the least understood. That's my opinion. That was me adding that to the list. What else do we have on emergency response? Ed McNamara.
This is more on the cyber, and that's the idea of clearance and who can talk to who, how you coordinate that, whether there's clear authority of what can be discussed. And I think that's, I know you and Sharon have raised that in other avenues, but this was another good state-federal discussion.
Marcus.
I think you were characterizing Chairman Kane's comment on the visibility to what PJM has as far as demand response, but in a different market structure, it's the opposite, where the majority of demand response is through the retail side and known to the states and not to the ISO. And so even though they're the reliability coordinator, they don't have the visibility into what the states have within their program. There is some emergency DR done at the ISO level, but the vast majority of it is only known to the states and not vice versa.
Very well said. Grace.
Well, just to follow up, talking about simultaneity, I don't think we have discussed a lot about what's the role of demand response, energy efficiency behind the meter generation and the distributed generation play in the distribution planning. We do have integrated states which still doing IRP, and for the restructured states, we do the distribution planning, and we need a better load forecast there. And I don't think we have a good handle about how do we handle demand response in load forecast, both in the retail side and also in the wholesale side.
Darren, I can never tell if your card is up or if you're just looking at me meaningfully. Is it up? No. Dennis Bergeron.
I don't know. This is a question about whether there's any way of stopping a cycle of things that I observe when we have these natural disasters. We have the Superstorm Sandy is a great example. It came sweeping up the East Coast. And in New York, people freaked out, and the politicians, it happened in some of the New England states too. This can never happen again. We can never have this kind of an outage again. The politicians come down on the public service commissions, the public service commissions come down on the utilities. This can never happen again. And in New York, they decided that they were going to rebuild their substations to the new 100-year flood maps of FEMA, plus 3 feet above. Now, how did they pick that number? They've got a design standard, but the next time the storm comes through, you're going to have a different set of politicians in office, a different set of public service commissioners, a different political reaction that says this can never happen again. Is there a way to break that cycle?
I'll write that down as a question.
Commissioners for life.
I may or may not write that one down. Other inputs, other thoughts? Santa Claus is coming to town. Well, I love a meeting that ends early. What would you all think just by nodding of heads or shaking no? Let's call it a day? What do you think? Commissioner Fleming, I would like to anything that folks are interested in contributing before we turn things over to Commissioner Fleming?
I think they're ready. I just want to once again thank everyone for being here these past 2 days. And I think having such a diverse group of representation has really contributed to just some amazing conversations and questions and comments. And I really am looking forward to continuing these conversations, and I think we've raised enough issues to keep us busy for a while. And the feedback I've gotten from people here is that they have found this a very worthwhile meeting. So I just want to thank each and every one of you for your participation. And with that, the meeting is adjourned.